some time, his attorneys wrote to the commission and said that he would not be appearing before this commission during this week. The reasons they gave include that he was busy preparing for his criminal trial, that his doctors have advised him to limit his movements because of his age and COVID-19, and that he was seeking legal advice on the implications of the recent amendments to the regulations of this commission. I do not want to comment at this stage on his reasons for deciding that he would not appear before this commission this week. The media have sent a number of inquiries with regard to him, including questions such as whether this commission will issue a subpoena to compel him to appear before it, and whether there are other dates which have been determined when he should appear. Since his attorneys informed the commission that he would not be appearing this week, in order for the commission to use its time optimally, arrangements were made for the matter that we are going to hear this week to be heard this week. This was a matter that was going to be heard later in the year. So the commission had to rearrange its plans so that we could use this week properly, which otherwise would be wasted. I decided, after the commission had received his response through his attorneys, to fix the date for the hearing of the commission legal team's application for an order authorizing the issuing of a summons against Mr. Zuma. I have determined that that date will be the 9th of October at 9 a.m. He and his lawyers have been informed that unless I'm satisfied on that date that there are good grounds for them not to appear, if they do not appear, that application will proceed without them. They have been informed that should they wish to make use of a virtual appearance before the commission, and if they inform the commission timelessly, arrangements will be made for them to appear virtually before the commission. But that application will proceed with or without them, unless I'm satisfied that there are good grounds for them not to be here. I have also determined new dates for Mr. Zuma's appearance before the commission, since becoming aware of the letter from his attorneys. Those dates are 16 to 20 November 2020. Those are the dates that I have determined. I know that in their letter, his attorneys said dates should be negotiated with him or with them. No dates will be negotiated with them or with him. This commission has made it clear to the attorneys who represented him before that this commission does not negotiate dates with witnesses. the commission fixes the dates and people are supposed to appear. And if they've got good grounds for not appearing, then they make an application, a necessary application, and show that they've got good grounds. And if I'm satisfied that there are good grounds, other dates will be determined. But we will not negotiate dates with witnesses. So the position as it stands is the application brought by the legal team of the commission for the authorization of a summons, the issuing of a summons against Mr. Zuma will proceed on the 9th of October at 9 o'clock, and the dates of 16 to 20 November 2020 have been determined for his appearance. That is all I wanted to say about that matter. Now we may proceed.
Thank you, Chair. Chair, the evidence contemplated for this week concerns matters related to the departments in the Free State dealing with housing. And in particular, a series of events that took place during 2010 and 2011 concerning certain prepayments, over R500 million made to suppliers in order to avoid forfeiting funds to the fiscus, what has been described as a fraudulent scheme of payments to suppliers, causing great prejudice and loss to the department. And that really is the focus of the evidence this week. Now, Chair, the witnesses who will testify will firstly be Mr. Moketsi, who came onto the scene later than the relevant period, but brought an application on behalf of the department for the department to review its own decisions. And that application summarizes most of the relevant facts, which are common cause between a number of parties, not all the parties, but the relevant parties. And Mr. Moketsi will take you through the events, Chair, to deal with the matters. Mr. Mokoena was the head of department at the time. He will testify to certain issues. And then Mr. Makachwa will also testify in relation to certain issues. But Chair, there have been a number of reports and investigations into this matter. The Special Investigations Unit have dealt with the matter. There have been forensic reports, a number of forensic reports, and there has been, of course, the application brought by the department, which involved a great deal of research into the events that happened. There was also a very, very thorough disciplinary inquiry, which is the focus of certain factual investigations that have been conducted for that purpose, and that too is a matter of record. So, Chair, it's not the intention of the evidence leaders in this matter to rehash all those investigations. It would be a matter of repetition. But what we would like to do, with your leave, Chair, is focus on two issues. One is the issue of accountability. Who was held accountable for what happened, and why were certain people not held accountable? That will be the first focus. The second focus would be to show that this prepayment scheme to suppliers that was devised in order to allow the department to spend over R500 million for little or no value under what has been termed by the court in the application as a fraudulent scheme is took place within a context. And that context was an entirely irregular background of irregularities in relation to procurement. From the start in 2010, matters went wrong or deliberately were caused to go wrong in an entirely irregular scheme. And that context in the housing settlements, human settlements department will be placed before you. Those two issues, important as they are, seem to have really escaped notice. And whilst it is important to tell the whole story for the purposes of the Commission, which we will do, it is those two issues upon which we will focus. Chair, there are a number of bundles that have been prepared. They contain the statements of 9 witnesses, not necessary to deal with the evidence of all 9 witnesses, as will become apparent. There is a file containing transcripts of the interviews with certain of the witnesses. Then there's a file which deals with the court proceedings and contains the judgment of a full bench of the Free State Division. Then there is a file containing a number of forensic reports, which it is not necessary to detail, but we will refer to certain aspects of those forensic reports. There's a file containing the relevant legislation and prescripts. And then importantly, there's a file which contains the disciplinary records. The full disciplinary record, which is there then, and the findings, 177 pages of findings, parts of which we will rely on as well, Chair, to complete the picture, which would otherwise not be complete. Those records are before you for purposes of the Commission, submissions, your findings, Chair, and any other purpose to which they may be put in due course. And then similarly to the asbestos matter, Chair, we have, together with the investigators, compiled an investigator's report, which sets out from beginning to end all the detailed facts, which is there as a matter of record, again for submissions and the final report. It's supported by documentary evidence, and again, it is not necessary to go through that. So, Chair, if by your leave, I can just deal with a few matters by way of opening, and then summarize the important events to which reference will be made in evidence, and then if we may deal with the evidence of Mr. Moketsi, who brought the application on behalf of the department for the department to review its own decisions in relation to the prepayments.
That's in order.
Chair, there were 2 applications, or perhaps still are 2 applications for cross-examination of Mr. Mokoena. Mr. Mokoena, the HOD at the time, in his statement, made certain allegations concerning a Mr. Matachwa and a Mr. Koloi. They both filed applications for cross-examination, but after correspondence with the attorneys and given the evidence that is to be led, they've put those applications on hold. So it is not necessary to deal with them at this stage, and they will in all probability not be proceeded with. I've dealt with the bundles and documentation that is before you, and I've dealt with what we will focus on in opening and in the evidence. The 3 witnesses have been named, and then a Mr. Zwane, who in a sense devised the scheme, the evidence will be, but was apparently, and I stress the word apparently, not held accountable for any of the outcomes of that scheme, and its illegality, manifest illegality, will be asked to explain his position in relation to that. In essence, what happened here is a number of junior employees were disciplined. And I say junior with respect, they were not mere functionaries, they were officials of some seniority, but the people who are ultimately responsible for the scheme and its implementation, no consequences followed. Chair, the background is important because it is important to understand the impropriety of the prepayment scheme within its proper context. In 2010, 2011, there were actually regular contracts entered into with contractors. And at a stage during that financial year, the normal, properly procured contracts were ready to be implemented. Then there came a change. The Premier at the time, Mr. Magashule, decided that there would be a change in the whole system. Bigger houses would be built, disputes arose with the contractors, and a new tender process had to be commenced. A new tender process was indeed commenced during the 2010-2011 financial year. But what happened was that by the time the bid adjudication committee came to consider the bids, the period of validity of the tenders had expired. Instead of regularizing the position by extending the validity of the period, or the period of validity of the tenders, instead of simply regularizing that, and there are various ways that are required to do that, it was just abandoned. Those who qualified in terms of the bids, those who were disqualified, including those who were declared incompetent to build, were all put on a database. And that database, certain officials, including Mr. Zwane, the evidence will be, merely selected who they wanted to do the work. So the contractors that were appointed during this whole process to receive goods from the suppliers, which accounts were prepaid, were there irregularly in the first place. Instead of going through a proper tender process, the relevant department simply abandoned the process, threw it overboard, and put qualified, disqualified on a database, and then just subjectively selected who they wanted to appoint. Huge contracts, 500,000 houses in municipalities in the Free State. So in the original process, Chair, 361 bids were received. 105 were disqualified for basic bid compliance reasons. Not properly registered, no tax returns, or other formal reasons, but important reasons. 147 were disqualified because they did not meet the minimum functionality threshold. In other words, weren't competent to do the work. There were 109 who qualified. 81 established contractors and 28 emerging contractors. That was the situation when the whole bidding process was thrown overboard because of an expiry of the validity period. So instead of reinstating the process, and there are ways to do that which will be dealt with, Chair, all those qualified and disqualified were put onto a database, and then at the discretion of officials, subjective discretion of officials, people were appointed to do work. Of course, this had alarming consequences at the end, which is the subject matter of reports. Contractors simply couldn't do the work. They walked off site. Monies disappeared, and all that is the subject of investigation in due course.
And of course, putting service providers on the database implies that as far as the department is concerned, they can be given jobs.
Correct. So it opens the door for subjective allocation of work
Yeah,
at the
including-
discretion of an official.
And if you put onto the database service providers that have been found to be not competent to do the job, it means you could be giving jobs to service providers who are not competent to do the job.
It's exactly what happened, Chair.
Yes.
In fact, the outcome of this whole process began here. It was disastrous for those people in the Free State who needed housing, low-cost housing. There was a huge national project for the development of low-cost housing. Originally, and in its conception, quite ironically, it was designed to avoid mismanagement and corruption, but that's precisely what happened in the Free State. So the first, in the 2010-2011 year, the first issue that has really not received much attention was that the foundations, well, there weren't very many foundations at the end of the day, but the foundation of the project, the housing project, was fraught with irregularities. Quite simply, a whole lot of qualified, disqualified people were put on a database, and from that database, people were then selected subjectively at the instance of particular officials. The detail of how the matter should have been regularized will be dealt with in evidence, Chair, but for the moment, suffice it to say that it was not a lawful option simply to abandon the process, simply because a particular time period had expired. We will deal with the regulatory framework governing both the appointment of contractors on the one hand and suppliers to contractors on the other. But what is clear from the start is neither contractors nor suppliers of materials to contractors were subject to any competitive bidding process, which, as we've dealt with in the asbestos matter, is clearly unlawful and inexcusable. So we will deal with Section 217 of the Constitution. We will deal with the Public Finance Management Act provisions, the Treasury regulations, and we will deal with the Division of Revenue Act. This money that was allocated by the National Fiscus to the Free State for the construction of houses was allocated in terms of an act colloquially called DORA, the Division of Revenue Act. And that act is quite explicit. It says that we are going to allocate money to the province for a particular express purpose, in this case, the construction of low-cost housing. The Act is very clear that if any of that money is to be paid to third parties, such as contractors or suppliers, it has to be done in terms of a regular procurement process, open bidding process, which complies with the supply chain management requirements of the province. That simply did not happen. That fact, it's clear, was concealed from National. So not only must goods be procured or services be procured from third parties in accordance with supply chain management policy or procurement policy of the relevant province, and for which adequate documentation for payment has been received. So not only that, but the purpose must be complied with. So it's only for housing in terms of the Act and in accordance with proper procedures. But then there's a third provision which is important in this case. It says you can't make advance payments to anybody. You have to have received the goods, or the services have to have been verified and done before you pay money out, for obvious reasons, to avoid precisely what happened in the province. That can only happen in two circumstances, according to DORA. The first is if the receiving officer in the Free State who receives the money has certified to the National Treasury that the transfer is not an attempt to artificially inflate its spending estimates and that there are good reasons for the advance payment or transfer. That, it's clear, on the department's own version, subsequently, was precisely the purpose. What happened was that towards the end of the financial year, the Free State had not spent over R1 billion of its income and had to devise a fraudulent scheme, well, a scheme which turned out to be fraudulent, in order to spend that money. And all sorts of mechanisms were devised to ensure that that money could be spent. Completely irregular schemes, and that story will be told and placed before you. But the second thing is that National Treasury must approve the advance payment. It didn't. And in fact, it was told something completely different, and that evidence will be placed before you. So this scheme that was devised, Chair, by the Free State Human Settlements Department, in order to spend the money before the year end, otherwise the money goes back to Treasury, was devised at the highest level. It was devised at the level of the MEC in a war room, Mr. Zwane. He devised it and executed it, and that war room supervised the execution of the scheme, the detail of which will become clear in the evidence of Mr. Moketsi. Not only did they devise it, but they ignored warnings from National that this was illegal and should not be proceeded with. And notwithstanding those warnings, the scheme was in fact proceeded with. The matter was done without proper legal advice being taken, perhaps for obvious reasons, because the advice had already been given by National that the scheme was illegal, and on the face of it was manifestly illegal. There are various elements of the scheme that will emerge in evidence. Not only were payments made to suppliers before goods were even supplied, but payments were made to suppliers and then on-paid to contractors as so-called bridging finance, which is not the business of the Human Settlements Department at all. And then, in addition, in order to ensure that as much money was spent as fast as possible, retainer agreements, retentions which would be kept back by the department to compensate for work poorly done or work not done, those rights were abandoned entirely. So even the retainer amounts were paid out prematurely. Of course, that had serious consequences because, as matters turned out, the result was all but hopeless, and that retention money was needed. But that had been foregone to ensure expenditure, and the detail of that will be put before you. The agreements that were entered into as part of the scheme, which the court found to be a fraudulent scheme, are quite complicated, but we will do our best to explain them so that they are accessible to those who have an interest in following it. But essentially, there were three levels of contract. The first is the contract with the construction entity, the builder. That contract with the builder was clear in its terms, was on the face of it regular insofar as the contents of the contract are concerned. We've already said that the selection was entirely irregular. But once the contract was entered into, it was the duty of the contractor to source the materials, to pay for the materials, to put the materials into the building, and then on 3 milestones being achieved, would invoice the department, and the department would pay the contractors. So the contract in itself was, on the face of it, quite regular. But in order to spend the money before the year end, because of course these buildings would only be constructed and these milestones would only be reached in the next financial year, but the money had to be spent in the 2010-2011 year, a scheme was devised to pay suppliers up front, even before goods were delivered to the builders. So a scheme was devised to pay the suppliers sums of money. With that money, the suppliers not only paid quote-unquote bridging finance to the contractors, which was not the business of the Housing Settlements Department at all, but the suppliers would enter into agreements with the department to receive monies and eventually to deliver goods. But those were all prepayments. 600 million rand, Chair, was spent in this fraudulent way.
But the whole idea was to avoid a situation where by the end of the financial year, the department had not used this money for housing.
Yes.
So there had to be, a scheme had to be arranged in terms of which it would appear as if they had used the money properly. For housing.
Yes.
But actually they had not used the money properly.
Correct. And that was the essence of the fraud found by the High Court. So the question is, who was accountable for that? And how did accountability follow for that? That is, the facts which I've just related, Chair, are in a sense common cause. Mr. Mkesi was the deponent to the founding affidavit where these facts were placed before the court. And they are fully set out, and we'll go through them in some detail and try and unravel them. They're quite elaborate in some ways, but quite clumsy in other ways. So, for example, in order to make this appear regular, and in order to provide documentation to the provincial treasury on which monies could pay out, there was a scheme that took some time for the legal team to understand, let alone communicate sensibly to anybody else, Chair, which I'll attempt to do, of sessions entered into. So there had to be a paper trail. Which
were those the sessions spelled with an S-E-S-S-I-N-O-N?
Yes, and sometimes it is spelled with a C, but you will see, Chair, that right until the end there was spelled with an S, and that's, I suppose, not to give them the qualification of a real session.
Yeah.
But you will recall, Chair, that we pointed out that any claim by the builder against the department would only arise once a milestone was reached, which would probably be in the following financial year. But what the scheme was devised whereby that claim against the department for materials as part of the work was ceded to the supplier. Of course, there was no such claim, upon which the supplier then, as part of the prepayment scheme, invoiced the department and got paid its money. And of course, even further, quite ironically, of course, there would be no claim because the supplier had already been paid by the time the session came to operate. But it's complicated, and I'll try and explain it properly in due course. But that whole scheme of sessions was the third layer of agreements, which were entirely nonsensical in a way. Then, of course, Chair, there were two other methods devised for getting rid of money quickly. The Free State Housing Settlement Department became involved in the job of bridging finance. And it emerged in the investigations that what the suppliers were doing with the money they received is they were handing it on to the builders before anything had happened as part of bridging finance. That is dealt with in a certain way, and I will deal with it with Mr. McKessie, who describes that whole scheme as quite frankly bizarre and uses those particular words. And then, of course, the abandonment of the right of retention. If the department has got 5% of all the expenditure on construction, it needs that money, and particularly needed in this case to remedy defects, but decided because we need to spend this money, we're going to pay that money out and not rely on the retention. So that money was also part of the scheme. That doesn't arise out of the application, that came out of further investigations, but that will be dealt with. It was dealt with in the disciplinary inquiries. So, Chair, there are a number of investigations too that have taken place. The Commission simply would not have the capacity to go into hundreds and hundreds of individual contracts to show why those particular persons benefited on an irregular and unlawful basis from the distribution of monies in haste during the 2010-2011 financial year. But we will highlight some matters which have been highlighted in the investigations and which require further investigation. And Mr. Maklachwa will give evidence in relation to certain of the matters that concerned him. He was, in fact, relatively low down in the seniority hierarchy, but he was one of the people that were dismissed. Stated, Chair, that there, quite interestingly, and perhaps a matter of concern in itself, there was an overdose of forensic reports in this matter. The Auditor General, quite properly of course, conducted its investigation and report. There was an entity called Open Waters Advanced Risk Solutions that was employed to conduct forensic audits. The Special Investigations Unit did its own. Nurture, NURCHA, Finance Company Limited, did an extensive investigation as well. And the outcome of all that has yet to be realized. That in itself is a matter of concern. How matters are investigated, who is appointed to investigate matters, and what is the outcome of that? And we will deal with that in submissions in due course. So, Chair, that is a very brief overview of the evidence that will be led. And if we may take you through the application that was brought subsequently to that series of events by the department itself, and Mr. McKessie will hopefully help us in that regard.
Okay, no, that's fine. Does that mean he is ready to be sworn in?
Yes, please.
Yes, before that is done, I didn't deal earlier on with a matter that I should have dealt with when I responded to some media queries with regard to Mr. Zuma. I think the media queries at different times have been about his appearance before the Commission, but also about the fact that he has not filed any affidavits before the commission to help the commission and to put his side of the story. I didn't deal with the last part. I just want to deal with that immediately because it is in the public interest that the public knows what is happening, particularly about somebody who was president of the country. And I just want to say that towards the end of August, I issued a directive in terms of Regulation 10(6), that is 10 sub-regulation 6 of the regulations of this commission, compelling Mr. Zuma to depose to an affidavit or an affirmed declaration to answer certain matters relating to ESCOM, with special reference to the affidavit submitted by Mr. Zola Tsotsi, who was chairperson of ESCOM at some stage, as well as the affidavit of Mr. Nick Linnell with regard to particularly a meeting that they both said had been held in Mr. Zuma's official residence in Durban, where, according to them, a discussion relating to the removal of certain executives at ESCOM was discussed, or a discussion took place relating to the removal or suspension of certain executives. That was towards the end of August, and I have also issued another 10(6) directive against Mr. Zuma in regard to another matter. The commission might not compel him to respond to all the affidavits that have been filed, but certainly there are certain affidavits that the commission believes are very important for him to deal with, and in regard to those, as the legal team makes requests for me to issue directives to him to submit affidavits, I will consider those requests and make a decision on the basis of each application or request. I thought I must just add that because I didn't deal with it earlier on, and it's a matter that the public has an interest on. Yes.
Thank you, Chair. Chair, before proceeding with the evidence of Mr. Moketsi, he is legally represented. May his counsel place himself on record.
Oh, yes, sure.
May it please you, Chairperson, I appear on behalf of Mr. Moketsi, together with my learned junior, Mr. Manye, instructed by Ms. Babani Maranyani of the State Attorney, Bloemfontein.
Thank
We
you.
understand he's merely a witness, and I doubt that you'll hear from me again
Yes.
in this matter.
Thank you. Thank you. Okay, administer the oath or affirmation, please.
Please state your full names for the record.
Nthimusa Mokgesi.
Do you have any objections to taking the prescribed oath?
No, I don't.
Do you consider the oath to be binding on your conscience?
Yes, I do.
Do you swear that the evidence will give will be the truth, the whole truth, and nothing else but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. You may be seated, Mr. Moketsi.
Morning, Mr. Moketsi.
Morning.
Mr.
We are
Moketsi,
happy that you are back, Mr. Moketsi. Yes. Mr. Pretorius, are you only going to deal with the housing matter in regard to him at this stage and deal with the remainder of his evidence relating to the asbestos matter on another day?
Yes,
are you
Chair,
going to
that is
deal
the
with both?
intention. Mr. Mpofu did appear this morning in the expectation that Mr. Moketsi would also be dealing with asbestos matters. Unfortunately, in our preparations, we weren't in a position to deal with both matters today, and alternative arrangements will then be made in consultation with Mr. Mpofu, the attorneys, and Mr. Moketsi. But I can give Mr. Moketsi the assurance that that period of questioning will be very short. And it could
Yes.
take place either on Monday or Tuesday next week.
Yes.
All parties willing, or even other arrangements could be made.
Yes, well, you just said in consultation with Mr. Mpofu.
Yes. After consultation with Mr.
When I've just said that we don't negotiate dates with lawyers and their witnesses, their clients. Okay, all right.
Although
If it's short notice, we can talk because it's short notice. But if it's reasonable notice, there is no
yes,
need.
Chair. Unfortunately, we did inconvenience Mr. Mpofu,
Yeah,
but
yes.
that,
Yeah.
that
Okay,
can
all
be
right.
sorted out in the spirit of collegiality, and it will be after consultation.
Yeah, well, as I say, if they are given reasonable notice, there is no need. But if you seek to have short notice, then it's understandable because they would complain of short notice. But if they are given reasonable notice, then there is no need because otherwise we would never get anything done if we have got to negotiate dates with lawyers and witnesses.
I understand, Chair, and
But Mr. Moketsi's other evidence should be dealt with pretty soon.
yes, it will
Yeah,
be, Chair.
yeah.
It must be, and
If
I
at all
think that at
possible,
least is common.
Next week, if at all possible.
Yes.
But you will have a look. Okay, all right.
Mr. Moketsi, there is a file FS14. Is that the file in front of you?
Yes, it's a FS14.
This file, Mr. Pretorius, I guess should be marked bundle FS14
Is your,
or not?
yes, it should be.
Yeah.
That is the file marked court proceedings.
Sorry?
Is that the file marked
Yeah.
court proceedings?
Yeah.
It should be. If it hasn't, that was part of the
Of the
flurry of
program.
activity
Yeah.
this morning.
Yeah, okay, bundle, it will be referred to as bundle FS14. That's the file marked court proceedings, exhibit UU 11.
Thank you, Chair. I understand, and there's no dispute about this, Mr. Moketsi, that during 2013, the Free State Department of Human Settlements brought an application before the High Court in Bloemfontein to review and set aside certain contracts that had been entered into with a number of suppliers. In fact, 106 of them.
Yes,
And you were instrumental in doing the necessary investigation and research, reading the necessary documentation, in preparing the papers for that application.
yes, I was.
If you would please go to page 95, you will see, Mr. Moketsi, and you're fortunately an old hand at this, that there are two sets of numbers at the top of each page. We will be dealing with the black numbers in the top left-hand corner.
Yes, I'm on page 95.
So, now, that is a founding affidavit. If you would go to page 173, please. At the bottom of that page, whose signature is that?
Yeah, that's my signature.
Is that the founding affidavit then that was brought during these court proceedings, attested to by yourself?
Yes,
And it appears from page 95 to page 174.
yeah, that's the one.
The notice of motion appears before that, after divider 2, one can ignore the summons proceedings in the first divider, but if one could go to page 60.1, please.
Yes, I'm on 60.1.
And that was the application to review and set aside the agreements with suppliers listed as respondents, 106 of them, and to set aside the decisions made by the Free State Department of Human Settlements to make the payments listed in Annexure 3 to the notice. Is that correct?
Yes, that's correct.
Right.
I'm sorry, Mr. President.
Yes.
Did you say page 60 point something?
Yes.
60.1?
Yes, Chair.
It doesn't look like I've got 60.1. I've got 61. And at 61 is the list of respondents. That's Annexure 1 to the notice of motion.
All right, Chair. There is a divider marked 2,
Yes,
a cardboard divider.
yeah,
The first page after that divider, may I ask what page?
61.
61?
Supposed to be 60.1.
60.1. Is it 60.1 or 61?
It is 61,
Well, then it's the incorrect page. Chair, perhaps this is
a convenient
if I
time.
may run for cover and return after the short adjournment.
Okay, all right. Let's take the tea adjournment and we'll give you a chance to have this attended to.
Thank
We
you.
adjourn. Okay, it looks like the pagination has been corrected.
Yes, for the present. Thank you, Chair.
Yes, okay. Let's continue then.
If you would go to page 60.1, please, Mr. McKenzie, of FS 14.
Yeah, I'm on page 60.1.
That's the notice of motion preceding the
I'm sorry.
affidavit to which we've
I'm
just
sorry,
referred
Mr.
the Chair.
Pretorius. I'm sorry, Mr. Pretorius. There is quite some noise, I think, from the aircon, which wasn't there before. At least I didn't notice it. It looks like it's loud. Did anybody ask for it to be put on?
I did.
Oh, you did?
But it can be put off. We were warned that it would be noisy.
Yes, it seems quite, I don't know if there's a way of reducing the sound so that it's not too noisy. I think somebody will look at that. Okay, all right.
Yes, thank you, Chair. Otherwise, we could just have it on during the breaks.
Yes.
That might be a way of solving the problem,
Yes.
but it is pretty hot down here.
Yeah, no, that's fine. We'll just have to see how we strike the balance. I don't want you to feel too hot. Okay, all right. I think they have reduced it. That should be fine.
Thank you, Chair. Mr. McKenzie, that is the notice of motion about which we've been speaking. Is that correct?
Yes,
And it seeks to set aside certain agreements with persons listed in the annexure of 106 contracting parties. And it also seeks to set aside decisions of the Free State Department of Human Settlements to make payments in terms of those agreements. Is that
Yes.
correct? The date of that notice of motion, I did refer to a document dated 2013, but this application was brought, as I understand it, in 2016,
yes,
some years after the events in question, which took place in 2010 and 2011.
yes.
If one could go, please, to FS 14 at page 96.
Yeah, page 96.
Yes. Paragraph 4. You have that?
Yes,
There you set out the sources of the information relied upon by you in this affidavit.
yes,
Many of those sources are not a matter of great controversy. They may be in certain cases in relation to certain persons, but generally speaking, those are the facts upon which you relied. Would you tell the Chair, please, what you relied on for the preparation of this affidavit?
First, as I've indicated in my affidavit, the first being the disciplinary records, because I think the disciplinary process was completed around about that time, 2016, and also the findings, as well as the SIU findings in respect of our communication. Also taking into consideration, Chair, that the report of the SIU is the report of the President. However, in the process, we have been working together with the SIU and also getting some information which made us to rely on this, for us to compile this motion.
But we'll talk about the SIU report in due course briefly, but just for the record, Chair, the transcript of the disciplinary hearing relied upon by Ms. McKenzie is in bundle FS 16, 17, 18, and 19. The findings are in bundle FS 19 at page 612 to page 788, and the SIU report is in bundle FS 15 at page 384. It's a report dated August 2015. Subject to that, and as far as you are aware, are the facts contained in this affidavit true and correct?
Yes.
Of course, many of the facts that are contained in this affidavit were summarized in heads of argument, which we also have available, Chair, prepared on the basis of the papers by Advocate Budlander, and those facts were found by the court, Paul AJ, largely to be reliable and correct. Do I understand that correct?
Yes.
And we'll deal with his judgment insofar as it's relevant in due course. Is that correct?
Yes.
Now, we've told the Chair that the events relevant to your evidence today, Ms. Moketsi, took place in the 2010-2011 financial year within the Free State Department of Human Settlements.
Yes, correct.
Who was the head of department of Free State Human Settlements at the time?
It was Mr. Mkwena.
And who was the MEC for Human Settlements in the Free State Province at the time?
It was MEC Zwane.
If one could go, please, to paragraph 8. If I may just put that on record. In paragraph 7, just by way of introduction, you say in the affidavit that this application arises from a set of agreements concluded in late 2010 and early 2011 between the department and a number of building contractors and suppliers of building materials, and to payments made by the department to the suppliers. Is that a correct summary of the application?
Yes.
Or the subject matter of the application?
Yes, that.
And then you explain in paragraph 8, the agreements relate
raise
to
your
the
voice,
construction
Mr.
of
Moketsi.
low-cost housing in the Free State Province. The department received a large conditional funding allocation from National Treasury to build low-cost housing. That's a correct statement of fact, I understand.
Yes.
Do raise your voice, Mr. Moketsi.
Yes.
Okay.
And the legislation which governed that funding allocation from National Treasury was the applicable Division of Revenue Act, DORA. Is that correct?
Correct.
You continue in the affidavit to say the agreements form part of a fraudulent scheme which was conceived by the department to disperse very substantial sums of money, mainly to the suppliers, in order to avoid the funds becoming a so-called unspent conditional allocation and therefore reverting to the National Revenue Fund. Is that a correct statement of fact?
Yes.
Would you explain it, please, to
Yeah. Perhaps also I must also be very careful because not everything that looks like fraud is fraud. And also to, because the sole purpose of this affidavit, also taking into consideration that the SIU was also on it, was really to try and persuade the court to give us a favorable judgment to recover the money. So that was really the whole purpose of this court proceeding in the main.
Well, if you simply have to describe matters as you believe them, genuinely believe them to be so. If you genuinely believe that this was fraud, that's what you say. It may be that you are mistaken, but if that's your genuine belief, that's what you say. If you don't genuinely believe so, you don't say so. You don't say you believe it to be fraud. If you say it appears to me to be fraudulent, that's what you say. So I'm just explaining that because
Okay.
I seem to detect that you think that there may be aspects in the affidavit where maybe you put statements in a certain way and you just want it to be understood in a certain context, or Mr. Pretorius may be putting certain propositions to you and you are not sure whether it's something you can agree to completely or whether you need to qualify it. So I'm just explaining that to you, that in the end, whatever you say must reflect what you genuinely believe to be the position.
I think what I can say with utmost commitment, it is that they were irregular in that way, because in the manner that they were done, and one cannot conclusively say it is fraud because, I'm advised or also informed that, there must be an element, a proven element of intention as well. It certainly looked like that, but,
You are quite entitled to say, this is how it looks to you, or this is how it looked to you at the time. You are quite entitled to say, well, it looked like that at the time, but since then I've had an opportunity to reflect. I don't think it looks like that. So nobody wants you to say something that you don't genuinely believe to be true. Okay?
okay.
Okay, so as Mr. Pretorius puts questions to you, just bear that in mind. Okay. Mr. Pretorius?
Well, let's deal with that briefly. We'll get into the detail in due course as to why you would have said in this affidavit it was a fraudulent scheme, and it said more than once, Mr. Maketsi, why the judge would have found it a fraudulent scheme, and why your counsel presented extensive heads of argument describing the scheme which was fraudulent. That scheme, what was its purpose?
It's mainly, I think, as you have also articulated, it was one meant to spend the money because it came. I'm informed that at that particular time, the department, I think expenditure of the department was around about 10%, and there was issues of concern that they will not be in the position to spend the money, the full allocation by the end of the year. So it came as a result of that, to try and spend what has been allocated, because there was also, it became clear that
Is it your analysis of what happened that the purpose was to avoid this money being taken back to National Revenue Fund, to the National Revenue Fund, if it had not been spent by the end of the financial year?
Yeah, ordinarily, it will be reallocated to other provinces. That's what ordinarily happens.
Yes, yeah. So basically, ordinarily, the province would forfeit the funds that had not been spent,
Yes, a certain portion,
a certain portion.
and it will be allocated and reallocated to other provinces
Yes.
who are spending. And that's how normally it works.
And what must happen before the province forfeits such money? What is required to have happened before the province
Well,
forfeits such money?
there will be reports that are presented of all the provinces in terms of where they are, how much they have spent up to a particular point. Normally, after half a year, you are expected at least to be as close as possible to 50%. And the projects that are running and the level of commitment that you have. And then you are given an opportunity to say, particularly for those who are underspending, then you are given an opportunity to make a case as to why your allocation or certain funds should not be taken away from yourselves and reallocated elsewhere.
Would it be correct to say, as a province or the department, you would forfeit those funds or a portion of those funds if either it's National Treasury or National Department, I don't know which one, concludes that you have failed to spend the funds sufficiently during that financial year for the purpose for which they were allocated to you?
You will be correct?
Would it be correct to say, as a department, you would forfeit such funds or a portion of such funds if either it's the National Treasury or the National Department, I don't know which one, you would know, concludes that you as a department have failed to sufficiently spend the funds that were allocated to you for the purpose for which they were allocated to you?
Yes, you will forfeit it. The first part is a report. Provinces that have not spent or that have not reached a specific milestone in their expenditure will then be identified. It can be one or two, a number of them. And those provinces will then have to make a sort of a recovery plan, expenditure recovery plan that will indicate, for example, how you would recover and be on track with the rest, and that is informed by the projects that are running, and with all that information, then the National Department will either say, no, we agree with you, or no, we don't agree with you, and therefore we are taking money anyway.
Yes.
And allocate.
Yes,
It's a question of a discussion between the relevant province and the National Department.
But in the end, you are not going to forfeit any money if the National Department believes that you are spending the money appropriately.
Yes, you will not, if they believe, if you have made your case.
Yeah, you persuade them.
Yes.
But if despite whatever you say, they are convinced that you are not spending the money sufficiently,
they take it in.
they'll take it away.
Yes.
Okay. Mr. Pretorius? So if I want to avoid that consequence, whatever I do, I would have to create the impression, at least, that I have sufficiently used the money for the purpose for which it was given to me, is it not?
Chair, maybe I'm misunderstanding your question.
In other words, if I don't want the National Department to conclude that I have not sufficiently used the money for the purpose for which it was given to me,
Yes.
I would have to create the impression that I have sufficiently used the money for the purpose for which it was given to me during that financial year. Then if I persuade them that that is the position, they won't take it away
They
from
must
me.
believe in your plan. First, they must believe in your plan that you are putting
Yes,
forward.
yes,
They have
yes.
to believe that,
Yes.
in your plan.
Yes.
If they don't believe in your plan,
Yeah.
they will take the money anyway.
Yes, okay.
And how they take the money is that you will not receive your next allocation. For
Yes.
example, if you are receiving just by way 100,000 per month, which goes to 1.2 million, I'm just making an example. The last two, they will decide and say, right, you are not going to receive for February and March, you will not receive if
Yeah.
they decide to take 200,000 or
Yes.
300,000, whatever the case might be.
Yeah,
So that's how it works.
it works, yeah. Thank you, Mr. Pretorius.
Mr.
I hope
McKenzie,
that has clarified
you've
something.
told, I'm sorry, Chair.
I'm saying I hope that has clarified something,
Well, it may need further clarification, if I may, Chair.
but by all means, continue if you seek to have more clarification.
Yes, thank you. You've told the Chair, Mr. McKenzie, of the sources that you relied on to prepare this affidavit.
Yes, yes,
They included the disciplinary hearing transcript, the evidence that was given in order to dismiss certain employees of the department, correct?
yes,
The findings of the disciplinary hearing, which resulted in the dismissal of certain employees, correct?
yes,
And the investigation carried out by the Special Investigating Unit, right?
yes,
You looked at those documents and you reached certain conclusions which led you, on behalf of the department, to attest to this affidavit for review, correct?
yes,
You say in paragraph 8 in this affidavit, the agreements which you seek to set aside form part of a fraudulent scheme which was conceived by the department to disperse very substantial sums of money, mainly to the suppliers, in order to avoid the funds becoming a so-called unspent conditional allocation and therefore reverting to the National Revenue Fund. Now, when you attested to this affidavit, did you believe that to be a correct statement?
yes, I believe.
Has anything happened for you to change your mind?
Well, to change my mind, simply that it was, the process was unlawful. Okay.
Well,
Because-
you know the process was unlawful. We'll go into the detail of that.
Okay.
You accept the process was unlawful,
Yes.
right? And you accept that certain representations had to be made to National in order to persuade them not to take your money away, correct?
Yes.
And many of those representations were not true, correct?
Yes.
And as a result, the law that should have been carried out, the forfeiture, wasn't carried out, correct?
There? Can you repeat that, Mr. Pretorius?
In other
Forfeit.
words, you were required to explain to National why they shouldn't forfeit the money,
Yes.
or why you shouldn't forfeit the money.
Yes.
Explanations were made, documents were put up, statements were made, many of which were false, correct?
Yes. Many. Yes.
We'll
many
come
of-
to the detail,
Okay,
don't
all right.
worry. I don't want to hold you to generalizations. We'll come to that. And as a result, what should have happened in accordance with the law didn't happen. The money should have been forfeited, but wasn't, correct?
Yes, the money should have been forfeited because the National Department did not accept the expenditure recovery plan of.
Well,
and on
we'll
that,
come to
on
that
that basis,
expenditure
you
recovery
forfeit the
plan.
money.
Because that in itself is a gross misrepresentation, but we'll come to that. And you say so yourself. So I'm not taking things further than what you say in this affidavit. Okay. But let's move on if we may, because it's all in the detail. You say it was a fraudulent scheme in your affidavit. You say it again in paragraph 10. You say the agreements and payments form part of a fraudulent scheme and are tainted by fraud. You say that yourself. Correct. It's not just a passing comment in one paragraph. You say it repeatedly throughout.
Yes.
Correct. Were you in court when your counsel argued the matter?
No, I was not in court.
Well, let me just tell you that your counsel argued strenuously that the scheme was a fraudulent scheme. Did you take note of the judgment of the court?
Yes, I've seen the judgment.
If I can just take you to FS 14 at page 599. That's right at the end of the bundle.
Did you say 599?
Yes.
Okay.
Paragraph 9, you would have read this and no doubt accepted the finding because you acted on it. If you look at paragraph 9 on page 602.
Paragraph 9.
This is the judgment of the court. Court was presided over by Lopser J. and Paul A. J. The matter was heard on the 26th of August 2019, according to this, even though the application was brought 3 years prior to that. The judgment was delivered on the 26th of August 2019, and in paragraph 9, the following is said, and I'm referring to page 602. The department was not able to spend the funding referred to in paragraph 6 supra fast enough and within the fiscal year to avoid the situation that most of it would revert back to the National Revenue Fund in terms of DORA. You've already told the chair about that. The judgment continues to read, the department therefore conceived an illegal scheme to facilitate the advance payment of very substantial amounts of money, mainly to suppliers, within the fiscal year so that the funds would not revert back to the National Treasury Fund. Judgment continues. The agreements that form the subject matter of this application were a key part of this illegal scheme. The agreements were unlawful for two major reasons. They were concluded without any proper procurement process having been followed, and the agreements and the payments made under them form part of a fraudulent scheme to avoid the consequences of DORA. That is the finding of the court. And it continues in paragraph 10, this illegal scheme was devised to allow the department to pay material suppliers very significant sums of money over a short period of time, in total more than 630 million rand over the period 2010 to 2011. That's the judgment that arose and was granted, or the relief was granted in accordance with the application that you brought. Now, if we could go back to page 10, so page 98 of the bundle, paragraph 10.
Yeah, page 98.
Page 98, paragraph 10. There, your affidavit reads, there are two major grounds on which the department seeks its relief. The first is that the agreements were concluded and the payments were made in breach of procurement law. The second is that the agreements and payments form part of a fraudulent scheme and are tainted by fraud. Those observations there in paragraph 10 are mirrored in the judgment and the portion I've just read, correct?
Correct.
Let's go to the components of the scheme, if we may, in paragraph 22 of your affidavit. Once again, you make reference in paragraph 22 to a fraudulent scheme, and if I can just read what you say in paragraph 22. I have said that this application relates to a set of agreements which the department concluded in late 2010 and early 2011 with contractors and suppliers. I have also said that the agreements form part of a fraudulent scheme conceived by the department to pay out funds from its conditional funding allocation in order to avoid the funds becoming an unspent conditional allocation and reverting to the National Revenue Fund. That's at least the third reference to a fraudulent scheme. Doesn't seem to have been an error on your part. Correct?
Yes.
And then you describe the major features of the scheme in paragraph 23. You say firstly that the department concluded some 125 written building contracts with contractors. Are you able to say when those were concluded? That was before the prepayments were made to suppliers, is that correct?
Yes. Yeah.
And what did those building contracts provide in relation to who would purchase materials, supply materials, and who would pay for them?
Yeah. It's a standard contract. Supplier, the contractor is responsible to purchase material and also to build, convert that material into a product referring to different milestones, whether it is foundation, wall plates, or completions. And then upon that, then the contractor will then, if he has completed the first milestone, like the foundation, the P5.1, he can then claim.
Right.
That's the basis, that's the contract, basis of that contract.
Now, these are standard building contracts that comply with the regulatory framework applicable to construction.
Correct.
What is important about that scheme that you've just described is that the contractor sources the materials in
Yes.
accordance with the needs of the contractor.
Yes.
The contractor can then certify that those have been delivered. Is that correct?
Yes,
And the contractor then incorporates those materials, such as they are, into the building.
The normal contract is the contractor. If I didn't understand your question, you can. The normal is that the contractor is responsible for procuring material. That's basically how it works. And he must convert that material into a product, the foundation, and then he must, once he has completed the foundation, that's the first milestone, he then can claim that foundation subject to the certification and the signing off by the engineer and so on.
Of course.
So that's the normal process.
So the process you've described has a number of checks and balances in it.
Yes.
That can put the client, the Department of Human Settlements, in a position of some comfort that materials have been ordered, supplied, incorporated into the building, and then certified to have been so placed in the building, correct?
Yes. We don't buy material, we buy a complete product.
Yes, well, however we describe them. But in the normal course, and in terms of the contracts that you entered into, or the department entered into with the contractors, the builders, that was the scheme that was to be followed. Am I correct?
Yes.
Correct, right. But then further agreements were entered into. By the way, it will become clear later that even those contractors were not appointed in accordance with a proper procurement scheme. You say that later, is that correct?
Yes.
We'll just flag that for the moment and deal with it later. But then further agreements were entered into. You say in paragraph 23.2 that despite the supply of materials or whatever being dealt with in the contracts with the builders or the contractors, further agreements were entered into. The department, you say in paragraph 23.2, also concluded some 112 written tripartite supply agreements with contractors and building material suppliers. A material term of these supply agreements was that the department would pay suppliers for building materials which the suppliers supplied to contractors. So now, instead of the original scheme that you've just described to the chair taking place, we have a different scheme. Is that correct? Which differs entirely from the first scheme.
From the first, yes.
Right? So here, the department was going to pay the suppliers for the building materials which the suppliers would then supply to the contractors, correct?
Yes.
Why was it necessary to do that?
It was not necessary. I don't know why it was necessary at the time.
You
to
do
work
know,
with
Mr. McKenzie, because you say so. But anyway, would you just tell the chair, please?
Look,
I could help you if you like, but I don't want to lead you on it.
yeah. The first, there was the second, what is it, the material supply agreements that were entered into with, I think it says 112 agreements. Now, this material supplier will then supply materials to the contractor, which in a way contradicts the first part, because the responsibility of acquiring material is not the responsibility of the department, it's the responsibility of the contractor. We are simply saying, so that the contractor can at a later stage claim. Now, here we have an instance where it now becomes the responsibility, that which is the responsibility of the contractor becomes the responsibility of the department. And this is where part of the problem also is. But it can only mean that, you know, by acquiring material, then you'll show a better expenditure per se. So that's basically.
Well, let's explain it, because it is important and it's fundamental to the substance of your affidavit and what happened afterwards, Mr. McKenzie. If one goes back to the original scheme, the way it was originally planned to happen in the normal course, the contractor enters into a contract with the department to build a house.
Yes.
It's the contractor's responsibility to source the materials
Yes,
and to use them in the house
house,
and to pay
yes.
the supplier.
correct.
There are 3 stages, 3 milestones. The first milestone is the foundation.
Correct.
The second is the
Wall plate.
walls of the building,
Yes.
correct? And the third is the roofing.
Yes,
At the completion of each stage, once the work has been checked and verified, the contractor can then claim the money from the department, and the department will pay if everything is in order.
yes,
And included in those charges that the contractor bills the department with is the materials that it has bought,
yes,
correct?
yes,
Now, if the house hasn't been built yet, this would only happen sometime in the future. Correct?
Yes.
That money would only be paid when the foundations are built or when the wall is built. Correct?
yes,
But the department had to find a way of spending money quickly. Correct? In order to avoid its reversion to the fiscus. Correct?
yes,
And so the scheme was devised to make sure that money could be spent before the year end. Is that correct?
yes,
You say as much.
yes,
Please, I'm not putting words in your mouth. And it was done through a device, a series of agreements, which, as you yourself say, made very little sense. And let's go into the detail then. In paragraph 23.2, a second set of agreements, the tripartite supply agreements, 112 agreements, were entered into, and in terms of those agreements, it was agreed the department would pay the suppliers for building materials, which were to be supplied or were supplied to the contractors, correct?
yes,
Even before the foundation was built, even before the walls were built, and especially even before the roof was put on, correct?
correct.
Then there was a third set of agreements, and these are the so-called session agreements, sometimes spelt with a C, sometimes spelt with 4 S's instead of just 3. Now, do you know what these agreements were? We
Session.
try and explain them to the chair because it is quite complicated.
Yeah. What gave rise to a session is, you cede your claim to a third party. Now, there cannot be a cause for payment if there is no claim. Now, and this is also a part of the problem because in that particular process, there was no claim or cause for payment against a claim because there was no claim to be ceded in the first instances because all these 3 agreements, in my view, contradicted each other. They did not make sense on one process.
Let's try and explain that in a way that those who are following the evidence can understand because it's elusive. You've told the chair that the contractor would have a claim against the department once the foundations were set, or once the walls had been built, or once the roof had been put on.
Yes.
Of course, when these session agreements were entered into, that hadn't been done. Correct?
Yeah, there was no foundation. There was no claim.
Yes. So at that stage, when these session agreements were entered into, in other words, when the claim of the contractor was given to the supplier, that's the session, there was no claim because the house hadn't been built, correct?
Correct.
So at that stage, the contractor had no claim to cede, correct?
Yes.
But nevertheless entered into a session agreement giving its claim against the department to the supplier for the materials, correct?
Yes,
At a time when no such claim existed,
yes,
correct? And even later, of course, there would be no claim to seed because the suppliers would already have been paid.
yes,
So there were problems with this session, not so. As you
Yes,
said,
there was.
this was part of the problem, correct?
yes,
But as you point out later in the affidavit, these very sessions were used as part of the documentation given to Provincial Treasury to persuade them to pay, correct?
yes.
Is that correct? Anyway, prior to the claim of the contractors even arising, and pursuant to these sessions, the department made payments to the suppliers in excess of 500 million rand. Correct.
Correct.
And you say in paragraph 23.5, as you've just said to the chair, there was no lawful cause for the payments. Correct? Now that's a general statement because, of course, some materials might have been delivered and some not.
Yes,
But the detail of that would depend on the detailed investigations being done by various bodies in relation to particular contracts, and we are not going there in this hearing. That, do I understand the position correctly? Right. But in 23.6, you say, the tripartite supply agreements between the department and the suppliers and the contractors did not give rise to a cause for the payments because the suppliers had not supplied materials to the contractors before being paid. And that was correct as far as you were concerned at the
as
time.
far as I'm concerned at that time, that was correct.
Yes. You've continued to say the payment structure in the supply agreements requiring supply before payment was not followed. The invoicing and certification requirements in the supply agreements were not complied with. Correct.
Correct.
Now, just to get back to the fraud, nowhere in the documentation, and in fact the contrary appears, does it appear that the Free State Department said to National, listen, don't take our money back because we're going to spend it in this way, but we must warn you that it's completely irregular, and we must warn you that these requirements are not being followed, and they are all prepayments. Nowhere was National told that, correct?
Yeah, no,
Correct.
correct.
Am I correct?
Yes,
Then in paragraph 23.7, you deal with the sessions. You say, nor did the sessions of claims by the contractors to the suppliers give rise to a cause for payments. This is because the claims which were purportedly ceded, that is, claims by the contractors against the department, had not yet arisen. You've just told the chair that. Is that right?
yes,
The contractors had not executed the construction works or portions of the construction works, nor had they provided materials to the department. The contractors therefore did not have claims for payment against the department. You've told the chair that.
yes,
And I take it nobody told National in writing or otherwise, look, there's a problem with all these contracts because we're prepaying and nothing has been done, and these sessions really aren't worth the paper they're written on. Correct?
correct.
Nobody told National
No,
that.
no,
So you say in paragraph 23.8, the department nonetheless paid more than 500 million rand to various suppliers over the course of 2009 to 2011. It did so purportedly on the strength of the session agreements. In other words, department officials used the deeds of cession as the paperwork justifying the instruction to their accounting staff to pay out. Department officials also manipulated the housing subsidy system to make it look as if construction work had been executed and that payments were therefore due, when in truth this was not the case. Those are correct statements of fact, are they?
Yes.
So not only were the sessions that seeded claims that didn't exist, or purported to seed claims that didn't exist, used to persuade accounting staff to pay out. But it's a complicated arrangement that was entered into, but milestones were inserted into the agreements, correct?
Yes.
And those milestones really weren't regularly inserted. And I don't want to go into the detail now. If necessary, we could go later. Correct. But the system was unlawfully or irregularly manipulated to put a milestone in the agreement which didn't really exist.
Yes.
Well, I asked you earlier, Mr. Moketsi, why the department implemented this scheme, which was clearly irregular, deceptive, and in your own words, fraudulent. And you deal with that at paragraph 24 and following. If you could just tell the chair, please, in your own words, why, what the reason was for this scheme to be implemented.
Well, Chair, I think it's simple. The reason why it went this way, it was to ensure that, the department does not lose money back to the fiscus and therefore to other provinces. So acquisition of material or paying of or buying material resulted in this particular type of a process or scheme. That was in the main why it was because there was a possible loss to other provinces of the money or of the conditional grant.
Right. In other words, it was necessary to persuade the National Department of Human Settlements and National Treasury to do what they would not have done had they known the true facts, correct?
Yeah.
You say yes?
Yes.
And you say that there was a threat that the unspent allocation would revert to National Revenue Fund. You say that in 24.2, to be reallocated to provinces with better spending records. And then in paragraph 24.3, you say, in the face of that threat, the department proceeded to implement the scheme, dispersing funds to the tune of more than 500 million rand from its conditional allocation, with no lawful cause for the payments to be made. Now, the department faced a difficulty. You have literally hundreds of contractors and over 100 suppliers, each with their own arrangements in relation to the supply of materials and its dealings with the department, correct?
Yes.
Were you able at this time to do sufficient investigation to examine each and every contract?
All 100 and...
Yes.
It was extremely difficult.
Right. You appointed several investigators to do that, correct?
Yeah, internally we could not do it.
Yes. And we have examples of what happened.
Yes.
For example, examples of charges being levied against the department with nothing being delivered.
Yes,
Correct.
we have examples of that.
Yes. And fraudulent charges, correct?
Yes.
But in paragraph 26, you make an estimate, which I think is worth putting before the chair. What do you say there in paragraph 26?
You wanted me to read it out?
Well, you can read it if you like. Let's just establish that you signed this affidavit in 2016, correct?
Yes.
By that time, had all these houses been built?
No, not all. Not all is.
Right, that's
yeah,
5 years later,
Sorry?
let alone in 2010, 2011.
It is.
Sorry, 5 years later, not all the houses had
Not
been
all the
built.
houses were built.
In 2010, 2011, how many of the houses had been built?
2010, 11.
Virtually none.
Well, I don't know.
Well, all
2010,
right, the reports will tell us
Yeah.
what had been done. That's not a matter of great controversy.
Yeah.
But the point is, you had spent in advance of the building of the houses something like 600 million rand.
Okay. Yes.
Correct. All right. But you say here, the department has, however, obtained reports which indicate how much more it will cost to procure that the housing which the contractors were contracted to build, the 14,769 units to which I referred to above, is built. It will cost the department an estimated further approximately 500 million rand. Then you say the calculation is not straightforward, but the department's best estimate is that it has lost approximately 866,000 million rand. That was your best estimate at the
That was
time.
not, yes.
Nearly $500 million
Is it
rand
not
Yes.
lost.
400,866,000? I don't know if you got the number right. Do you want to?
400
You may have
million,
got it right. Yeah, just might.
866,000.
400,866,000.
Yes.
Yeah, okay. You may have got it right first time around. I might have just had something else.
I could easily have got it wrong, Chair.
Yeah.
Let's just say that almost R500 million was spent before anything was done,
Okay.
more than R500 million. And the ultimate loss to the department was in the region of R500 million.
The ultimate, yeah, 400 and,
Yes.
Yeah,
So,
400 million.
and this is in relation to building houses for people who need houses to be built to live in. It's for low-cost housing, correct?
yes, this is for
That's
low-cost
what the
housing.
money should have been spent on.
Yes, this is for low-cost housing.
So this money that was paid out to contractors, about about 500 million was paid out, is that right? And then, but you say the loss is 400,866, is that right?
Yeah, Chair, I think the estimate is
Yeah.
the
it's not
equivalent number of
accurate, yeah.
houses. How much is it going to cost
Yes,
the department to build?
Yes.
That's why the 500 million.
yes.
And
But
then we
the
also,
actual amount that was paid out is how much?
no, we are not there. Okay, the actual amount that was paid out, I think,
We haven't dealt with it, I thought
yeah.
we had.
but I think what is being tried to be explained here is that the houses that were supposed to be built at that point, the 14,706, this is the estimate of
Yes.
how much it will cost, 500 million.
Yes,
But already we had made advance payments.
yes,
And that 486 million is probably what has not been accounted for in respect of the advance payments that were made. Because
Yes.
it's not in all instances where material were not delivered and houses were not built.
yes.
There are instances, there are houses that have
Yes.
been, but as to the extent of the value that we have received, it was a
Yes.
problem to say, and that's why we also had to I think we did two actions. One, as they say, is before the review application, the action proceedings, just to force the contractors to give us invoices, delivery notes, and so on and so on.
But as things presently stood at the time of your affidavit, and I guess maybe even now, but certainly at that time, your estimate was that the department had lost more than 400 million rand.
Yeah, we could not properly know
Be accounted for.
accounted for as to,
Yes.
because
Yes.
of this particular.
But money had been paid out to people. Some houses had been built.
Some
But
not.
when, some were not, and it looks like there were many which were not.
Yes,
And your estimate was the department had lost more than 400 million.
yeah. Which might well have changed over time.
Yes, but at that time,
because
when
they
you
were-
deposed to the affidavit, that
Yes.
was your estimate.
Because I'm aware of, even though I'm not exactly sure about the amounts that were recovered by the SIU
Yeah,
in the
yeah.
process.
Okay. But by whatever account, it was substantial amounts
Yes,
that were not accounted for.
correct.
Well, we know that, and Chair, the figures vary by 100 million rand at times, but we know from your affidavit that more than 500 million rand was spent as part of this scheme, this irregular scheme of prepayments to suppliers. That much we know, correct?
Yes,
We know that there are examples, and these examples emerge from the various investigations that have taken place of unqualified builders just walking off site, and that money being therefore lost, correct?
correct.
And there are many other examples of losses. But the first point is that this unlawful, irregular scheme of prepayments, and we'll describe it yet again in your own words in a moment, cost the department in the Free State over 500 million rand. Correct. You then,
And just make sure, Mr. Mukherjee, your response is
Yes.
captured, yeah.
Yes.
you then did an investigation and you estimated how much more have we got to spend in order to complete the building of these houses. And you say that that would have been over 500 million rand. You say that in paragraph 26, of course, an estimate.
Yes, it's an estimate.
And you say in the last sentence, the calculation is not straightforward, but the department's best estimate, and that is best estimate in 2016, is that it has lost approximately 400,866,000 rand. Correct.
Yes,
Substantial amount of money. Now, at 50,000 rand per house, I've just been told by someone who's done the calculation, that could have built over 8,000 houses. That's a substantial amount of money
yeah,
on any calculation. Now, of course, as you point out, that this was difficult to establish because you've got hundreds of contracts, hundreds of transactions, each one different in its own way. Many fraudulent, many suppliers didn't supply, many claims were overstated, but it's a massive job to investigate each and every single contract, and that you've employed people to do.
yes,
Then in paragraph 27, if we may go there, you made a submission. You said, I submit that the department's scheme was a fraud on the national government, specifically on the fiscus. It was also a fraud on the public, on all who expect state funds to be spent regularly or properly, including on improving the standard of living of the poor, on those in the Free State and in other provinces with an expectation of receiving state-funded housing, and on all taxpayers. That, I understand, was your belief at the time.
yes.
Anything to change your mind?
No, No, not really.
Not really. Then in paragraph 28, you say, I have described above the fraudulent aspects of the department's scheme. It is important to point out that the contracts were also unlawful because the department did not follow any lawful procurement process before concluding them. This is in itself a ground on which the contract should be declared void. In case we haven't made it clear already, Mr. Moketsi, the selection of the suppliers to which payments were made will come in due course to how those people were selected, perhaps not in your evidence, but in the evidence of witnesses to come. But what we do know, there was no open tender and bidding process that preceded the appointment of suppliers. We know that as a fact, correct?
Yes.
You give the factual background, and it's not necessary to go into too much detail here, Mr. Moketsi, because we've dealt with it in some respects already. But what was it's in paragraph 30 and following of your affidavit at page 105 and following of FS 14. What was the breaking new ground project of the cabinet announced in September 2004?
Sustainable human settlements.
Yeah, it was a comprehensive plan for the development of sustainable human settlements, correct?
Yes.
Which included the building of houses.
It included the building of houses, and it's a whole comprehensive plan.
The infrastructure
it's not
required.
infrastructure, building houses, amenities, social amenities, and so on. Not only about houses, but also to understand that and that's why the change from housing to human settlements, because then it takes into consideration the entire community, whether it be social amenities, infrastructure, and so on, as we've indicated.
So
That's
this
what it
was
is
a
about.
comprehensive and ambitious plan to provide sustainable human settlements for poor people.
Yes.
Right. And you say in the last sentence in paragraph 30, among the ways it tries to achieve that aim are easing delivery constraints, increasing building capacity, and rooting out corruption and maladministration. At least that was the intent. Correct?
Correct.
Then in paragraph 31 and following, you set out certain facts, and it's necessary to deal with those in paragraph 32. You say, in pursuance of this scheme, the Breaking New Ground low-cost housing project scheme, funds are allocated in terms of the Division of Revenue Act to provinces each year.
Yes.
You've told the chair that. But paragraph 32 is important. That allocation, you say in paragraph 32, is a specific purpose and conditional allocation. In other words, a province receiving funds is not unconstrained in how it spends those funds. In other words, when the money is allocated to you by National Treasury in terms of DORA, that's the Division of Revenue Act, is the province free to spend it as it likes?
No. You have to spend it first, in terms of the housing code, where you can spend it, and in terms of the approved business plan. So you can't just spend it.
There's a
Whichever way.
housing code that governs the
That governs,
expenditure.
yeah, to make sure that you fall within the policy framework. And also, of course, the business plan also approved by the National Department and then determines how you're going to spend money where and in what area.
Now, we know in relation to the business plan that the National Department under Minister Sekwali at the time said, you must give me a plan. Otherwise, this money is going to be lost to the province. And that was the expenditure recovery plan. We'll come to that in a moment because that was a representation to National, which we will see was completely misleading. But let's first deal with the points you make in 32.1 to 32.3, Mr. McKenzie. The money is given to the province. The province obviously has to disperse that money to contractors and to other parties, people who build infrastructure and the like, advisors and the like. Those are third parties.
Yes.
Now, in relation to third parties, what are the restrictions in the Division of Revenue Act? You deal with those in 32.1 to 32.3. Those are important for the purposes of this evidence.
Yes. You know, there is a standard way of when money is allocated. You must spend it on the approved business plan and approved projects. They will have been identified, which projects are. You should have planned before. You know, you don't do your planning in the year that you're supposed to implement. The planning, implementation precedes planning. And those particular projects that you are going to spend the money on will have then be pre-approved through a process before, before we start the financial year. And, you know, that's how the process works in terms of different programs within, you know, infrastructure and as well as housing.
So you would tell National how you're going to spend the money. They would then give you the money. You would be obliged to spend it in accordance with those plans.
With those particular plans. And you will also have an opportunity halfway, you know, through, through half yearly to either revise your business plan because certain projects are not performing as they should. And that becomes a matter of discussions.
Right.
Yeah.
But
between
at
yourself
all
and the national
times,
party.
the way that the allocation is managed in terms of the Division of Revenue Act is that there must be complete transparency between the provincial department and the national department
Yes.
and Treasury.
Correct.
They must be informed exactly what is being done with that money.
Correct.
Correct. Right, and in relation to payments to third parties, for example, contractors, there are special restrictions in the Act. Am I correct?
Yes.
The first is that the province must have entered into a payment schedule with a third party. In other words, there must be a schedule which says precisely when and how much must be paid to the third party and on what performance, correct?
Yes, it's based on your contractual arrangement between yourself. You know, if it is, obviously, if it is houses, that payment schedule will be per milestones, etc.
As per the contract, the
As
first
per the
contract
contract.
that we spoke about with the contractor.
Yes.
But that didn't exist with the suppliers.
No, it didn't.
And
Only,
then
only
32
insofar as what we have seen as material supply agreements, which I think
Well,
are
you
problematic.
make more explicit statements later, but we'll come to that. Paragraph 32.2, the payment must be for services rendered by or goods received from the third party. That's the first thing.
Yes.
services must have been performed and the goods must have been received.
Yes,
No prepayments.
yes,
And those services or
there-
goods must have been properly procured in accordance with supply chain management requirements. In other words, you can't spend a DORA allocation unless you spend it in accordance with a proper supply chain management process. Correct.
yes,
And we know that in relation to contractors and suppliers in this case, those simply didn't exist. That didn't happen. Correct.
yes,
And then 32.3, advance payments to third parties, i.e. where services have not yet been rendered or the goods not yet delivered are subject to specific requirements, including the approval by National Treasury. So before the province can make any prepayment, you've got to tell National Treasury and get their permission. Correct.
yeah, there is a framework that clearly indicates how prepayment are to be done. And they must be part of the contract, first and foremost.
Yes, and that didn't happen in this case. Well, certainly approval by National Treasury was not obtained.
Yeah, I think you don't necessarily need approval of National Treasury, but the framework has been laid by National Treasury that this is how,
Well, firstly, you say here that one of the specific requirements includes approval by National Treasury. I must say, on our understanding of the law, that's correct. That statement is correct.
That's in
it is correct
32.3.
because National Treasury has laid out the framework.
I'm saying that is in paragraph 32.3 of your
32.3.
affidavit, yes.
Yes. National Treasury has laid out the framework under which you can make advance payments. Right. That framework is there in terms of Treasury regulation.
So are you saying in other
must
words
Yeah.
that by putting up or prescribing that framework, National Treasury has given approval that provided you act within this framework, then you have our approval.
Yes.
That's what
That's
it
yes.
means.
Yes.
Okay.
If it's prescribed, you can't move outside that particular
Yes,
framework.
yes. So in other words, what you are saying is, you might not be required to obtain separate or specific approval from National Treasury, provided you have acted within that framework that National Treasury has approved.
Yes. If for some other reason there is any, because of circumstances or whatever the case might be, you are unable to
Comply with the framework.
comply with the framework because of good reasons that might be there,
Yeah.
then you'll have to go back to National Treasury and make your case.
Oh, okay. Mr. Pretorius?
All right, so what you're saying in paragraph 32.3, you now say must be qualified by the words or
The framework.
and compliance with the framework
Yes.
that laid
compliance
down
with
by
the-
National Treasury.
Yes. There is a
We'll
framework.
look at that and I'll come back to you on that because the evidence of persons from National at the disciplinary inquiry was somewhat different, but let's not deal with that now. I'll come back to that.
Okay.
You say in paragraph 33 clearly, if a conditional allocation has not been spent by the end of the financial year, it reverts to and must be repaid to the National Revenue Fund. That we've established, right? Then you say in paragraph 34, for the third or fourth time now, the agreements at issue in this application form part of a fraudulent scheme contrived by the department and the respondents to circumvent the provisions of DORA and avoid the department's unspent conditional housing allocation reverting to the National Revenue Fund. Do I understand it that you believe that to be true and correct at the time,
Yes,
and nothing has happened to change your mind?
yes.
Correct.
Well, it's important, Mr. Mukherjee, that your answer, particularly to that question, be heard, because I think that somewhere much earlier, anybody listening might have thought you had second thoughts about describing the scheme as fraudulent. So I'm just saying,
Well,
to the extent that you say nothing has changed your mind, it's important that
Yeah, I
that
think-
comes out clearly.
Okay. No, I think you have clarified for me,
Yes.
Chair, earlier on,
Yes.
to say whether I believed. It's not
Yes.
that it actually
Yes.
is,
Yeah.
you know,
Yeah.
and that
Yeah.
to me gives me
That's still your belief. Yeah.
comfort, because I'm not competent
Yes.
to say something
Yeah.
is fraud or not, but if
Yeah.
it looks like fraud, it doesn't mean that it is fraud.
Yeah. Okay, no, that's
You know,
fine.
So,
Well, let's, because that's a qualification that you haven't placed before the chair before in very clear terms in answer to my questions, and perhaps I should be fair to you to allow you an opportunity to explain. You've said not once, but several times in this affidavit that the scheme was fraudulent, right? We will go into the detail provided by you to show that it was in fact fraudulent. We can leave that for the moment, but
Okay.
we're dealing with a conclusion that you reached here, right? At the time, I take it, because this is a statement on oath, that you believed it was fraudulent on all the research that you had done, correct?
yes.
Can you now give any reason why it wasn't fraudulent?
I say I believe that it was fraudulent. And I think I've said I cannot say with, let me put it this way, I believe it was fraudulent.
Correct.
Okay, yeah. And I think the chair has sort of indicated to me to say, the fact that you believe does not necessarily mean it was.
No, the chair has suggested nothing to you, Mr. Mckenzie. This is your evidence.
I don't
Chair
think
made
you...
no
you are-
suggestion of any sort of that to you. All the chair said to you
what
was
did
that
the
you're
chair say?
free to give evidence as you now believe to be the case.
I said so. I said I believe that it was, at the time, I believe that it was a fraudulent at the time. And I still believe that it is.
And you still believe so?
I still believe that it is.
Great.
So,
All right. And there's been no revelation to you outside of the reports that you referred to earlier that would persuade you that you were completely wrong or partially wrong. Correct. No new information has come to your attention.
Oh, no new information has come to my attention, yes.
Is that correct?
Yes.
All right, let's just go, please, if you would, to paragraph 35 of your affidavit on page 107.
What page? 107.
107, Chair. Paragraph 35. The total allocation, however it is made up, we needn't go into that detail for present purposes, for housing in the Free State for the 2010-2011 year was 1.42 billion rand. Substantial amount of money, correct?
Where are you reading? Or 35, or the last person?
I'm sorry, I can't hear you.
No, I was saying, where are you reading from? Which
Paragraph 35, second last line.
Okay. Yes?
Correct. And the plan was during the course of 2010-2011 and 2011-2012 to build 21,050 low-cost houses, apart from everything else that you've just mentioned, correct? Is that correct? You
Yes.
see that in paragraph 36, third last line.
Okay, yes, yes, I see it.
Correct. Now, we know that wasn't achieved. The extent to which it wasn't achieved is the subject of investigations, correct?
Yes,
Then in paragraph 37, you give the detail of what we've summarized for the chair earlier, that the 2010-2011 financial year ended on 31 March 2011. By late 2010, it was very clear that the department would not be able to spend the Breaking New Ground allocation or even a meaningful portion of the allocation by the end of the financial year. Correct.
yes,
Now, there were several things that happened to cause the delay in spending. One of them was that the plans for the sizes of the houses were changed. Correct. You had contracts, or the department had contracts to build 40 square meter houses. The idea was changed to build 50 square meter houses, and a number of contractual disputes arose. You say that in paragraph 38, correct?
yes,
And you say in paragraph 39, in addition, a tender which the department had put out in early 2010 for the construction of low-cost houses lapsed and was cancelled, as I explain more fully below. Now, those circumstances, Mr. Mokesi, preceded the prepayment scheme,
yes,
and you describe it fully later on. And we believe it's important as a legal team to go through that in some detail, because the whole housing arrangement in the province, from the very beginning, from the appointment of the contractors right through to the prepayment to suppliers at the end of the financial year, was completely irregular, with the result that the housing scheme in the department was, to put it at its lowest, a total failure. And it's important to place that context before the chair, because that context hasn't really been given any prominence in material to date. So that's something new that we could put on the table for the chair. Chair, could we do that after the adjournment?
Yes, we can do that after lunch. We'll take the lunch adjournment now and resume at 2 o'clock. We adjourn.
lapsed. And then the BAC
I'm
did
sorry,
something.
Mr. Pretorius. The tender validity period, what does that refer to? What period is that?
Ordinarily, it will refer to the validity of the tendered price, because if that period passes, then you have to go back to the bidder to see, are they still on the same price? In other words,
Does that mean when a bidder submits their bid, they would say, we'll do this job for this price,
correct?
but this price is valid only up to a certain date?
Yes.
Is that what you're
Normally-
talking about?
Normally, 60 to 90 days.
60 to 90
90
days?
days. It will,
And that period is fixed by the bidder individually, or is it fixed by the department?
it's prescribed to say that will be the validity period. In an event that it goes beyond that, you will then have to go back to the bidders and say, are you still on that price?
Yes, so it's prescribed in terms of the regulations?
Yes.
In terms of the National Treasury regulations?
Yes.
So when you invite bids, the invitation to bid would include something that says the period will be X.
X, yes.
Is that right?
Yes, it's
So
prescribed.
when you refer to the tender validity period having lapsed, that's the period you're talking
Yes.
about?
And,
Okay.
and hence the earlier statement by Mr. Pretorius to say you could, the regularization means you ask the tenderers
Yes.
to say, are you still on that price?
And if they say yes, you continue?
You continue, yeah, and then you can
Yes.
continue.
Okay, all right.
Yes, thank you, we'll get there. Ms. McKenzie, the decision, however, that the BAC made was to say, well, we must cancel the tender and we must take all those who qualified and all those who were disqualified and include them in a database of service providers. Is that, as you understand, the decision that was made?
Yes, in terms of the documents that NM, yes,
That was the decision that is recorded in the following paragraph 75.5. But what is interesting is the minute of that meeting, which reads, the chairperson indicated to the committee that the tender has been evaluated, but due to the fact that the validity of the tender has expired and they cannot adjudicate, they have to cancel the tender. But as you've pointed out, that's not correct. There's no obligation to cancel the tender. You can take steps to regularize.
yeah, it's you can, it depends. You can cancel. You can decide to ask whether they will still be,
Well,
It's really a choice that we'll have to make.
you can cancel, but then the obligation to have a proper procurement process still remains.
Yes.
So you can't cancel for the reasons that they gave, is that right?
No, you can cancel because it has expired, but also because the validity period has expired. You can do that.
Yes, but what I'm saying is they cancelled because of certain reasons, as I understand it. They still wanted to use the money, from what I read here, to still use the money. They say appropriately, spend the money appropriately.
Yeah,
Could you spend the money appropriately without a tender on a matter that required a tender?
Yeah, the best way that they could, given that everything was okay, the only issue was the validity period. It's simply to communicate with the bidders and say, are you still on that price? And if they are still on that price, you continue with the evaluation and the award, etc.
Yeah. Okay.
Yes, well, we've done a little investigation ourselves into the matter, Mr. McKenzie. The first point is that the only option was not to cancel the tender. They had other options. We're agreed on that. Yes. You have to say.
Was that a yes,
Yes,
Mr.
okay.
Mkhwezi?
Sorry, yes.
Yeah.
In the first place, they might have taken the trouble to complete the process timeously and without delay. That was the first option. We know that didn't happen. The second option is that before the expiry of the tender period, they could have extended it unilaterally. Before its expiry, they could have extended it unilaterally.
Is that correct, Mr. Mkhwezi?
No, remember the issue, particularly the price issue. To be fair to the tenderers, you must actually indicate to them, because you can only hold a price for so long. The fixed price, taking into considerations that because we are dealing with construction here, prices are not statics. They are rising. So to be fair to them, you must indicate to them, are you still on those particular price? Yes or no?
So you can do
That's
that.
the practice. Whether you can do that unilaterally,
Yeah.
you
You might not be sure about that.
I might not be sure about that, but
In practice.
in other instances, issues have been taken where we are doing that. You have to inform the tenderers to say, are you still on that particular price? Because that price, ordinarily, it will be valid for a period.
Okay. Mr. Pretorius.
Yes, we'll give chapter and verse to the DC, to the chair in due course. But you're quite correct that there's another step that must be followed. Before the expiry of their period, the department could have initiated a process to extend the period. It would then have required some communication with the tenderers that would either say, extend your bid at the same price or bid again.
Yes, depending on what is the outcome of that. Because I would imagine, even on the tender documents themselves, that period will have been specified.
Yes,
So it's only fair to go back to them to say, we have extended, are you still on that price? Yes or no?
So a bidder could have said, look, you're extending it, but I'm withdrawing my bid. Right? Or it could have said, I'm agreeing to the extension, my bid remains the same. If this happens, this should happen before the period expires. But even after the period expires, you could, for example, cancel the old process and start a new process.
Yeah, you could cancel, you could cancel and start the new process. But also again, you also have to indicate that you have canceled.
Well, you could say to the bidders, and that's one of the options that's allowed, you could say to the bidders, listen, the period has expired, we want to continue with the process, will you maintain your price?
Yes.
Or do you want to give us a new price?
Yes.
So that's also, option is also there. But what you can't do, Mr. Mkhwezi, where you are required to have an open tender process, is just forget about the process and establish your own database at your own discretion. You can't do that.
No, you can't.
Yes. Okay. Anyway, so that decision was approved according to your statement or your affidavit at paragraph 75.7. That decision to cancel the tender and to establish a database in the discretion of the department was approved on the 30th of July 2010 by Mr. Mokoena, and we'll ask him about that. You see that in paragraph 75.7.
Oh, 7, okay. Yes.
So when you were looking at this whole thing, Mr. Mokgweetsi, did it appear like the bid adjudication committee said, look, the tender validity period has expired, but we do need to do what we were going to do through a tender period, so we'll just do it in a different way. We will put everybody on the database, and then we'll choose who will be given the job. Is that the impression you got when you were going through this whole thing to understand what was happening?
Yeah, but you can't do that because certain of the bidders were disqualified anyway.
Yes, no, that's a different point. I'm just asking your own understanding as you were looking at this whole thing before preparing the affidavit. Is that the impression you got, that this bid adjudication committee said, look, the tender validity period has expired. We wanted to achieve a certain objective through the tender process. We can't do that now, or we are not going to do that now, but we will do what we were going to do through another process, namely put everybody into the database, and then we will choose who will get the job from
No,
that.
but that's not the choice, irrespective of what the circumstances are. You have to follow a part. You can't decide your own process.
Yes, no, but listen to my question.
Okay.
Okay, my question is looking at what your own understanding was as to what this bid adjudication committee sought to do when they found that the tender validity period had lapsed.
Yes.
Was your impression that they decided that the way to achieve what they wanted to achieve through a tender process was to put everybody into the database and then choose the people who would get the job from the database?
It seems like
Yes.
from the
affidavit.
facts and the affidavit, it
Yeah.
seems that that was the
Yes, the approach.
The approach.
Yeah, okay, all right.
Well, then let's just summarize that, Ms. Mokgweetsi, and I understand that that is what you are saying. In the first place, the department must appoint contractors through an open tender process. That's obligatory.
Yeah.
So when something happens, such as what happened here, the period expired, one must rectify it.
Yes.
But one is still bound to have an open tender process.
Well, assuming that there was an open tender going towards that. Remember, this is about the extension of the validity period. So the process of open tender would have happened because we are simply indicating to the bidders, are you prepared to remain at the same price?
Yes.
Yes or no?
Yes. So if the remedy had been applied, if the process had been remedied through an agreed or imposed extension, whatever it was,
Yes.
then that would have been an open tender process, is what you're saying.
Yes. Yes.
It would have been a continuation.
It will be a
of the
yes. It
open
will be a
tender
continuation.
system. Yes.
Yes. Assuming that everything was done, there was an advertisement and specification, evaluation, and so on. And then at the evaluation point, then there is the validity period expires, and you go back to the very same tenderers and say, right, are you okay with can you hold on that particular price? Yes, and then you continue the adjudication and award.
Yes, because in that case, the remedy would have been put in place, the same process would have been continued to its conclusion, and then there would have been a proper assessment of the bids,
Yes.
proper and fair assessment of all the competing bids, correct?
Yes.
What one can't do, however, is throw the whole process overboard and simply select your own database.
Yes.
And
No,
that's
you
what
can't
you say here. You say in paragraph 76, the department thus decided to award contracts to contractors on various databases, as well as to the contractors who had bid for the tender notwithstanding that 105 of the bidders were disqualified for basic bid compliance reasons, and that a further 147 were disqualified because they did not meet the minimum functionality threshold. Those 252 disqualified bidders were simply allowed back into the process. And then some decision was made, and we're not sure how that decision was made. We will inquire in questions as to who would get contracts.
Yes.
Do you know who in particular decided that particular contractors would be appointed?
I don't know.
You concede, however, as the chair has already pointed out earlier this morning, that that process is fraught with danger because people can be appointed for the wrong reasons.
Yeah, yes, it leaves too much discretion to individual or individual.
Were you able to understand how anybody could do this, Mr. Mose? I just can't understand how anybody could do that. I mean, you know that there are people who, there are service providers who have been found to be disqualified to do this kind of job. And during the open tender process that you have now decided to ditch. And then you say now all of you must come back qualified or disqualified. You will, we will see, you are now all eligible to be given the job. I can't understand how anybody could do that.
No, it shouldn't have been like that. So
but were you able to, is there anything any information you got that made you understand how anybody could do that kind of thing?
Unfortunately not, Chair. I don't know why they would in that particular fashion.
I mean, I don't know. I'm just thinking of a situation where you need teachers for a school. People apply. You select. You say, okay, these ones have qualifications. These ones don't have any qualifications, or these are underqualified. Because something has happened about the period within which they had to apply, you say, no, all of you come. Qualified or not qualified, you can be appointed to teach whatever class. I just can't understand how anybody could do that. And maybe there's something that I will still hear that will make me understand, but I just can't understand. I mean, if they said, well, those that were eligible, that qualified, we will take only those, then subject to the legalities, you know, one would say at least they are looking for people who qualified. But to then say we'll bring everybody, whether they were qualified or disqualified, we'll now bring them together, we'll choose, just doesn't seem to make sense at all.
No, it shouldn't have been like that, Chair. I agree.
Yes, Mr. Pretorius, maybe you have worked with this thing for quite some time. You are not shocked like I am.
There's no acceptable explanation. That's the simple answer. But Chair, the various investigations have produced some examples of contractors who weren't equipped to do the job, having been given contracts to do the job and utterly failed in the execution of the project, or simply walked off site. There's several examples of contractors just deciding, well, they've got the money,
They took the money and left.
yes. So there are examples of that, and that is why each particular contract and arrangement should be investigated, because there's somewhere there are allegations of links between illegitimately appointed contractors and officials. We'll come to some allegations in that regard in the evidence in due course.
Okay.
And of course, whilst all that was happening, a number of relatively junior employees get disciplined and dismissed, and those who should be held accountable aren't, and that will become clear in due course. So you summarize in paragraph 78, Mr. Moketsi, you say in the second sentence of that paragraph, none of them, and you're talking of the building contracts that were concluded in and around July 2010, none of them was concluded pursuant to any proper procurement process. The department simply gave the contracts to contractors on its databases or to contractors who had submitted bids for the lapsed and cancelled tender. So they were simply handed out. What we don't have in this affidavit is who made the decisions to distribute contracts and on what basis those decisions were made, and thirdly, what the consequences are of that type of decision-making process. But we will come to that in due course in other evidence. And perhaps references will be made to that in the course of time with your evidence. But as far as you're concerned, do you know who selected the contractors who were to be given contracts?
No, I don't know.
Yes, we'll give detail of the example in due course, Chair. A disqualified contractor was indeed appointed, and according to the Nurture NURCHA report, performed miserably. What is important too in paragraph 80.2, and remember we're putting together the whole jigsaw of facts here, Mr. Moketsi, is that in terms of these contracts, it was the contractor's obligation to provide, and I quote, all of the necessary materials, labor, plant and equipment to erect the project.
Yes,
That was the building contract.
that was the building contract.
And then in 80.4, just to give chapter and verse to your earlier evidence, the contractor was entitled to payment of the amount set out in Appendix 1 per milestone and date as set out in Appendix 1, read with Appendix 3. That would be the sort of payment plan that was provided for in the Division of Revenue Act, I presume,
Yes,
which said before you can pay money to a third party out of this DORA grant, you must have a payment plan or schedule.
yes, that identify the work that you have to do.
Yes. What must be done and
How
by
many
when?
units, how many foundations, how many this, how many.
Yeah.
Yes,
And then the contractor was required to deliver to the department a claim for payments of all amounts it considers to be due, which shall be verified by the department prior to processing and payment. So there would be a claim, you would say, for 200 foundations of the 500 houses to be built.
yes,
That claim would be put in after the work is done and after the materials had been supplied, and it would have to be verified on inspection by the department. Am I correct?
yes,
So in other words, the expenditure of the state is safeguarded by processes,
yes,
let alone the process of appointment in the first place by fair and open tender. But even the execution is closely governed.
yes,
None of those provisions were applied to the 600 million in this case. Is that correct?
yes,
That's correct.
yes,
Remember, you are talking to me,
yes.
Mr.
Oh,
Moketsi.
sorry. Yes,
I need to hear what you are saying.
So Appendix 3, which is the project plan and what is required by DORA as the payment schedule, is dealt with in paragraph 81. There must be details of progress, milestones, and financial projections. Do you see that in paragraph 81?
Yes.
So you summarize that in paragraph 83, Mr. McKenzie. You say the basic structure of the agreement is nonetheless clear. The department would make payments to the contractor against completion by the contractor of particular stages or milestones of the works, with the works claimed for to be verified by the department. Is that correct?
Yes.
And you make the point in paragraph 84 that that accords with construction industry practice, and also in paragraph 85, the housing subsidy system. What is the housing subsidy system, if you would just tell the chair, please?
It's a project management system that the sector uses, and it records all the milestones and for housing, and whether it's infrastructure and so on. So that's the housing subsidy system that we are using for all the provinces. In fact, the sector as a whole. The Department of Human Settlements uses that, and the reports on how many or what we have done come out of that system. So that's basically what the system is. It's basically a project management system.
So you again summarize it, and you provide some detail in paragraph 85.5 on page 123, Mr. McKenzie. It's also consistent with the evidence you're giving now. You say, I emphasize that achieving a milestone involves construction work. For example, the foundations milestone involves digging the foundations, throwing the appropriate slab, installing the necessary piping for services such as sewage, water, and the like. And then you say, importantly, the materials relating to a particular milestone must be used by being incorporated into the construction work before the milestone is met. The milestone is not met if the materials are standing loose on site. The principle behind this is expressed as the requirement that government achieve value for money before it makes a payment. So there are two things that emerge from that, Mr. McKenzie. I take it that that's a correct summary of the position.
Correct.
The first is that before the contractor has a claim for the first milestone, the foundations, all that work must have been done and verified.
Yes, before.
And the second thing is before the supplier would receive any payment from the contractor, all the materials would have to be in those foundations.
Yes.
And then you make the point in paragraph 85.6, a contractor's work must be checked before the department or other organ of state feeds into the housing subsidy system the information that a particular milestone has been reached and that payment can therefore be made. And that is a complex and controlled process in terms of various regulations and provisions. Is that correct?
Correct, yes.
And then in 85.7, you say a contractor on a government-funded housing project is thus only entitled to an interim payment against his or her having achieved a properly verified milestone. Now that, you say in paragraph 86, accords with National Treasury requirements, DORA requirements, as well as all the building regulations that exist, and including the housing subsidy system.
Yes.
Correct.
Yes.
If we could go back then, please, to paragraph 40. I'll give you a page in a moment.
108.
It's on page 108. Are you there?
Yes.
Paragraph 40 records that the National Department of Human Settlements, as a practice, I presume, monitored what the provinces were spending of their DORA allocations. That was its duty, correct?
Yes.
And in October 2010, 6 months into the financial year, the monitoring exercise indicated that 4 provinces, including the Free State, had not met their monthly spending targets, nor their monthly targets for the delivery of low-cost houses. That was a fact in 2010 in the Free State.
Yes.
Minister Sekwale, who was then the Minister of Human Settlements, raised concerns with the various provincial MECs and issued a notice and said to the Free State and the other provinces, I want to see your expenditure recovery plan, what is referred to in your affidavit later as the ERP. Do you see that?
Yes.
In other words, you were saying, show me how you're going to fix this.
Yeah. Yes.
You make a representation to me as to how this situation of underspending is going to be remedied, otherwise you forfeit,
Yes.
and the money will be differently allocated. Is that like bothering you?
No, not really.
Is it okay?
That's still okay.
So, in paragraph 42, you say, the MEC, you've told us that that was Mr. Zwane, and the department's senior officials met to develop a plan to improve expenditure. And you say in paragraph 42, the expenditure plan which the department developed and which I describe in more detail below projects a very high rate of expenditure over the period November 2010 to the end of March 2011. We'll look at the plan in a moment because the plan itself, as you will probably recall, is quite remarkable for what it says and what it doesn't say, but we'll get there. Paragraph 43, well, let's first deal with one issue. The name is instructive, Expenditure Recovery Plan. Manifestly, the whole object of the plan was to make sure that the money, the 1.4 million, wasn't taken away from the province.
Yes. Yes.
So what the purpose of the plan would have been was to persuade the National Department and Treasury not to take the money away.
Yes, not to take a certain portion of the money, not all of it, and this is measured against the performance to say this is what we are likely going to achieve, and we, as it later turned out, it only 200 million, I think, 263 million.
236 million.
36, sorry.
Well,
236.
that depends on what you told them, but we'll come to that. The corollary to that is that if you didn't manage to persuade them, they would have put the money to lawful and, in their minds, better use by giving it to performing provinces.
Yes, that's normally what will happen. That's what happens.
Yes.
Money is reallocated to other provinces that are performing.
And of course, if the department, the National Department and the Treasury is persuaded on false information, they are then prevented from doing their job in terms of the legislation by allocating the money appropriately.
I don't know. The National Department was not convinced about the recovery plan. They took the money anyway.
Right, well, we'll come to that. what they were told and what they were not told, right? And whether they, and on basis of what information they finally made their decisions. But let's go to paragraph 43. And what you raise is important because they warned the provincial department about non-compliance. And you say that in your affidavit, not so?
Yes.
Paragraph 43, you say, by the time the department developed that plan, that's the expenditure recovery plan, October 2010, it had already started making unlawful payments from its fiscal allocation to some contractors and suppliers. The high rate of expenditure projected in the plan for the period November 2010 to March 2011, those are the remaining months after the plan was developed, was premised on and dependent upon such unlawful payments continuing. Furthermore, by the time the department developed the plan, it knew, because it had been told by the National Department, that such payments were unlawful and must stop. Correct?
Yes, yeah.
So, the unlawful payments were unlawful in several respects, as you pointed out. Firstly, they were made to persuade the National Treasury and Department that money had been properly spent and that all was in order. Correct?
Yes.
And furthermore, they were unlawful because there had been no proper procurement process.
Yes, there was no.
And that it was unlawful too because they were advance payments which hadn't been processed in accordance with the requirements of
Correct.
DORA. Correct. And Treasury regulations.
Yes.
Correct, yes. So you say in paragraph 44 that the department knew that the plan was unlawful, yet continued to make the payments. Do I understand your statement correctly here?
Yes.
So you say the payments were unlawful because no contracts were in place with the suppliers, no proper procurement process had been followed, and neither the National Department nor the National Treasury had authorized or indeed even knew about the payments. Those are the advance payments.
Yes.
Correct. So National Treasury wasn't told, look, we've made a whole lot of payments, they're advance payments, and that they're probably unlawful because no procurement process was followed. That information wasn't given to National.
Yes.
It came to learn of the situation through other means, which we will come to in a moment. Paragraph 44.2, Neville Cheney, who was Chief of Operations of the National Department, had learned, and I emphasize the words had learned, that the department was making unlawful payments. Now, as you say, Mr. Moketsi, that information would have been gleaned by you in the disciplinary proceedings that took place after 2010-2011. Am I correct? Do I understand the position correctly?
Yes.
What he said in those proceedings was, no, I wasn't told this, or the National Department wasn't told this by the province. We learnt through our Chief Financial Officer picking up the payments on the housing subsidy scheme ledgers. Is that correct? Is that in accordance
Yes,
with what
that's
you
how
report?
they will pick it up.
Yes, they picked it up with the very words used. Correct. You recall that?
Yes.
Yes. And he says, or he said, and you record this at the top of page 110, Cheney discussed this with officials from the National Department and the National Treasury. In other words, his discovery or his information that payments were being made. The officials agreed that the department's payments were unlawful. The officials also agreed that had the department, that's the Free State Department, approached the National Department or the National Treasury for permission to make such advance payments, permission would have been refused. In any event, that was Cheney's evidence. For the record, Chair, it's in Volume 17, Free State Bundle 17 at page 253 and following. I can go there if you wish.
No, that's fine. Thank you. I've noted.
It seems, at least from Mr. Cheney's evidence, that he was of the understanding that permission from National Treasury had to actually be given before advance payments could be made. That was at least his view. No framework here.
No.
Permission.
I think let's clarify that. In circumstances like this, for example, which clearly will fall outside the framework, you will then have to go to National Treasury or Treasury, so that you can also outline how we are going to manage, because the issue here is not to lose money, how we are going to implement this particular scheme, if I may call it that way. But there is a standard framework that says, yes, prepayments are allowed, or advance payments are allowed, provided they are part of a contract. But clearly, this is an exception here. What we're dealing with here is an exception. It will require outside permission from Treasury. It's not like me and you, one contractor, advance payments or prepayments, and I simply apply that particular framework, and then we agree on specific milestone. For example, he's a small contractor. He's not able to execute because he's an SME and so on. In that instance, you do that particular advance payment, but it's part of the contract, which might also include that the department must co-sign with you on the bank account, for example. All those particular controls will then put in place.
I
So it is in
understand.
that
If we could
context.
just summarize then. I'm sorry I interrupted you. Had you finished?
Yeah, I'm done.
The framework you talk about makes provision for advance payment provided certain conditions are met.
Correct.
The circumstances that we're dealing with in this case clearly fall outside that framework
And the sheer magnitude of it.
and the sheer magnitude. Right, fall outside that framework.
Yes.
So we can put that framework aside. In this case, it would have been necessary to get the permission of National Treasury.
Yes.
Okay, and that permission wasn't obtained.
No, it wasn't.
Okay. You say in paragraph 44.3, the national departments
sorry,
and the
Mr.
National
Pretorius.
Treasury's main objection to the payments was that they were advance payments.
I'm sorry, Mr. Pretorius. I'm sorry. Now, were there situations, practical situations, such as these, where the existing framework was not used, but the National Treasury was approached for approval as to what should be done? And if so, did the National Treasury give approval for that situation, in effect saying you can work outside the framework, existing framework? Or did something like that never happen practically?
I can't recall any of those circumstances that they ever existed.
Yeah, yes,
Because, the advance prepayments or advance payments are more of an exception rather than the rule.
yes.
the rule is, you know, you pay, work gets done, and
Yeah,
pay, you know.
yes,
Or in certain instances where there might be some sort of a premium, particularly in big contracts, in huge contracts, you know, what they call site establishment. Site establishment, it's a sort of a prepayment, if you look at it, but it will have been contracted upfront to say, to help the contractor to set up site. You know, he need money because they have not started working as yet. So it will be a certain percentage, 10% of the value of the contract, and that's. But it's within the framework to say it must be contracted to, it must be a part of it, but not at the scale that we are talking about.
but apart from the question whether at a practical level, you know of any situations which arose, in terms of instruments, regulations, is there a provision that says if you can't work or if you don't work within this framework, existing framework, you can approach National Treasury outside of that framework for something, for approval to be given outside of that framework?
Well, not that I'm
Or is it
aware.
something
Not
just-
that I'm aware of. Remember, Treasury is the custodians of the financial rules and regulations.
Yes, yes, yes.
Now, where there is uncertainty around a particular issue, we'll
Yes.
always go to them
Yes,
and solicit
Yes.
their view and request their support or approval and so on.
yes,
That's normally what you will do, particularly if you are not certain.
yes. So when you say approval could have been, or the National Treasury could have been approached for approval, if I understood you correctly, you're not basing that on any specific provision in any regulation.
No.
You just think that because they are the custodians of these regulations, if you have difficulty working within the existing framework, you might have to approach them. What they will say to you is something you don't know. They might say, hard luck if you can't work within
you
the
can't work,
existing framework,
yes,
or they might devise something for you. You don't know whether they would be able to.
Yes, they might come up with a better solution as
Yes.
to how to approach this particular, you know.
Yeah,
So you never know, because obviously they will be evaluating the risk in terms of what you want to do.
okay, all right. Thank you, Mr.
DCJ, this is a matter of law and regulation. We'll provide you with chapter and verse.
Okay, all
There's
right.
also a judgment of His Lordship, Mr. Justice Plaskett, dealing with these,
Yes, okay, all right.
which we will also provide. Paragraph 44.3 on page 110, Mr. Mokesi, reads, the National Department's and National Treasury's main objection to the payments was that they were advance payments. Monies were being transferred to contractors or suppliers without any work having been done or materials having been received. That was their complaint, as I understand it.
Yes.
Yes. And then you say, and in fairness to yourself, you explain it a little more thoroughly here. You say in paragraph 44.4, one of the basic features of the state's policy on state-funded housing schemes, and this is reflected in various regulatory instruments, is that payment may only be made against value actually received and only on the achievement of set milestones. You've told the chair about that.
Yes.
In other words, the state as employer will only pay a contractor for a construction job once the job has actually been completed. Intra-progress payments are permissible, but only for predetermined, defined sections of the job, and then only once those sections of the job have actually been completed. The department's payments to suppliers and contractors breached these basic requirements because the suppliers had not supplied any materials and the contractors had not done any work. That is the summary of the situation. there, correct?
Yes,
Is that correct?
yes, correct.
But of course, the money has now been spent. And it may seem obvious, but it's perhaps worth emphasizing the whole purpose of these controls and provisions is to ensure that the people who need the money and the services provided by the money get those services properly paid for and fairly spent. Correct?
Correct.
Let's look at this expenditure recovery plan, if you will. If you could go, please, to page 226 of FS 14. Now, to make clear the context, once again, of this plan, this is now in October 2010. Half the year has already gone, and this is an expenditure recovery plan to take place in the remaining 6 months of the year. October, November, December, January, February, March. If this is the plan at page 226 of bundle FS 14. Do you see that? Do you
Yes.
recognize this
Yes, I can.
document?
Yes, I see it.
All right. It contains various provisions. It's actually a slide presentation. But if I could ask you please to go to page 229. I'm sorry, it's page, I'm confusing myself with red and black numbers, Chair, my apologies. Go to page black number 232.
Yes.
It's actually over the page that I wanted you to go, but in fact I wasn't confused. Please go back to page 229. Ten-point plan on expenditure recovery plan continued. Are you at page 229?
Yes.
The plan says that projects must be classified into two groups. Group A, ready to run. Focus on all projects that are ready to run, it should read. 50 projects with 4,844 housing units. Focused approach on costing of foundations, wall plates, and finals. That would include the roof, I presume.
Yeah.
Correct?
Yes.
In other words, what this plan was saying to National Treasury and the National Department is we're going to actually build the houses.
Correct.
Yes. And if one goes to, well, at least 4,800 of them, if one goes to page 233, one sees the cash flow projections.
The 233.
Yes. In other words, what the Free State Department is saying to National Treasury and to the National Department, in order to, quote, recover the expenditure, unquote, in other words, to avoid the loss of the expenditure, is that this is our cash flow projection. This is what we're going to spend in the various months remaining this year. I understand that document correctly, do I?
Yes. To say
So-
up to the end of the financial year, this is how.
Yes. So it says November 2010, and then there are various items of expenditure under that heading, correct?
Yeah.
Totaling 256 million rand.
November.
I've rounded the figure.
Oh,
Look at the
okay.
total at the bottom,
Okay.
correct? In other words, what the department was telling National Treasury and the National Department was that in November 2010, we would do 8,500 foundations. We would expend 170 million rand. Wall plates on the foundations, walls, 3,500. And then another expenditure figure of 86,593,500. So there would be 8,500 foundations, 170 million, 3,500 wall plates, 86.5 million. You see that?
Yes.
And so it goes on. In December 2010, the cash flow projection estimated an expenditure, if you look at the total of the bottom, of 201 million rand. Correct?
Where are you?
Are you with me? Look
No.
at December 2010,
Oh, December 2010.
that column.
Yeah,
2,500 foundations, 50 million would be spent.
yes, yes.
Wall plates, 3,500, 86.5 million rand would be spent.
Yeah,
There would be 3,000 completions, and the expenditure there in relation to those completions would be 65 million rand. But the total would be 201 million rand spent.
yes,
January 2011, the various components would result in a total expenditure of 149,759,500 rand. You see that?
yes,
February 2011, it was projected that 220 million rand would be spent on the various components listed in the cash flow projection schedule. Correct?
yes,
March, 170 million, 4,300 rand. And the total, in the figure in the bottom right-hand corner, for all that work for the remaining 6 months would be an expenditure on work actually completed of 1 billion rand, 38,230,900. Correct.
yes,
So this is the expenditure recovery plan that the national minister says to the department, give me information as to how you're going to spend the money by the end of the year in order to persuade me not to forfeit the money or not to cause you to forfeit the money to the Free State Department. This is the representation or the answer it gets. It says by the end of the financial year, we would have spent 1 billion rand. Correct.
yes,
Now, it must have been obvious to the Free State Department at the time that this could never be achieved. You would agree?
yeah,
In fact, this is a complete misrepresentation of the position because at the time, there was a parallel project of advanced payments being made. Correct?
yes.
So can you give any explanation other than this is a complete fraud on the National Department? It's a difficult question for you to answer. I
honestly
know you
speaking.
account to people, but there can be no other explanation, surely.
Yeah. So
agree with
it's not practically possible to spend that amount of money.
When they prepared this document, this would have been in which month of 2010? October?
Yeah, it would have been October.
I think your
To say-
affidavit may be saying October.
To say for the rest of the financial year.
Do you recall, are you able to say roughly how many houses or units they had been able to build from the beginning of the financial year to October?
So at that time it was even very difficult to reconcile because of this particular problem.
But as you sit there now, did you get to conclude how many houses they had practically built
No,
and completed?
I will have to, no, I can't say it off the
Yeah,
cuff. There
yeah.
would have been
Yes. But you,
some houses.
it's a figure you can find out.
Yeah, there would have been, because you can extract that information from the HSSC system.
Yes.
There would have been perhaps a few houses and work in progress in a form of milestones, foundations, so many, and so on. There would have been.
Yes.
But
The reason why I was asking is that one might be able to say they themselves would have known that if from April, May, June, July, August, September, October, if in 7 months they'd either not built any houses or they'd built houses that fall below a certain number, there was no way they could build so many houses within the time that was left in the financial year, and given certain practicalities that they knew.
yeah, I'm normally, on a yearly basis, there will be some of houses that have not been completed, that are only completed in the current financial year.
Yes.
That move.
Yes.
Where at the end of the year, you'll have so many units and a certain portion will be work in progress, so many foundation and so on, and so many wall plates, but not completions. And then you move this, we will move with that
To the new financial year.
in the new financial year.
Yes. But of course, in that situation, do you use the money of the new financial year to complete those, or do you
Well,
carry over some money?
Remember the expenditure framework is 3 years. So you have to look at the 3-year
Yeah.
period
Cycle,
to
yeah.
say, on this particular financial year, I'll probably end up, you'll have the targets
Yeah.
to say 3,000 targets. You look at the budget, yes, but it's units and sites as well. And then units, it's across all programs, not necessarily RDPs, but it might also be affordable rental accommodation. So units and sites, and that's basically how it will go. And then, in this particular, you can have instances where some of the projects flow into the current financial year, and you also, and that's why there will be rollovers that are approved, because you have existing projects that are running that you can show to say, I request a rollover. I did not spend, but here are my commitments. And then National Treasury will then approve and say, right, we have existing contracts that are running. Now, your budget in that particular year will have been, let's say it will have been 100,000, but because of the approval of the rollover, maybe of 200,000, the budget for that party becomes 1,200. The rollover plus the budget for the current year. So it moves on like that.
But if I recall your evidence earlier correctly, you said that as at October 2010, the National Department was saying that, or had determined that the Free State Department had not exceeded 10% of expenditure in the funds that had been allocated. Is that correct?
Yes, the report was saying,
Yeah.
the monitoring report was saying you have only spent 10%
Yes.
of
the allocation.
the allocation.
So now, what it means now, when you look at this document at page 233 that Mr. Pretorius was dealing with, is that the 10% of 1 billion would have been about 100 million, more or less. Yeah. So,
Possibly.
So effectively, they were saying, even though in 6, 7 months, we were only able to use 10% in the balance of the months of the financial year, namely November, December, January, February, March. That's 5 months. And we know that there are holidays during December, and the construction industry normally doesn't work for some of that period. They were saying during those 4 or 5 months, they were going to spend 90% of the allocation.
It seems
That's what they were saying.
that's what the recovery
Something that
was
would have been quite remarkable.
was attempting to say.
Yes, okay.
The provisions of the Division of Revenue Act do, I understand, also deal with the 3-year medium-term expenditure framework. But for the purposes of this matter, it was saying that in the financial year ending, the single financial year ending March 2011, unless the allocation of 1.4 billion was spent, all or part of it would be forfeited. Am I correct?
Repeat that again, Mr. President.
In other words, you mentioned a 3-year medium-term expenditure
Yes.
framework provision that is provided for in DORA, as I understand
Yes.
my recollection of DORA. But what we were dealing with here is a single financial year,
Yes, it's a single financial year.
ending March 2011.
Yes.
And what the National Treasury was saying, unless you spend your allocation of 1.4 billion in that year, you're going to lose all or some of it.
Unless you spend and you can demonstrate by contracts, existing contracts that there are commitments for this money. It doesn't mean that you'll be able to spend it. And that will also allow you to get an approval for a rollover, because those projects are going to be running into the new financial year, so that you don't use the money allocated for the subsequent financial year with the projects that come from the previous financial year.
Now, if that, I'm sorry.
Yeah.
Yes, I understand. And in fact, part of your 1.4 billion, or part of the department's 1.4 billion, was in fact a rollover from the previous year, the 2009-2010 financial year. But that's a detail that maybe is in other information. But the point is that the department wasn't saying, look, we have contracts in place and we want to roll over. What it was saying, as is now clear, and you fairly conceded, Mr. Mokesi, is that we're going to spend over R1 billion in the 5 remaining months of the year from November to March. And this is how we're going to spend it, in all the details set out on page 233.
Okay.
And you fairly stated that it would have been impossible to achieve that, correct?
No.
Yes.
Well, is it correct that here in this document, they just state maybe what can be referred to as their targets, or maybe their plans, but I don't know whether it can be called plans, because unless you draw my attention to something that I haven't picked up, it doesn't look like they show in this document how they will achieve these targets within the time frame that was that they had.
Yeah, that, for example, if you say 3,500 wall plates, I'm just making.
Please raise your voice.
If you say 3,500 wall plates, for example,
Yes.
where are they?
Yes.
Right, because it means there must be 3,500 foundations somewhere.
Yes. And there must be contractors with
On
whom
site.
you already have, who are on site,
Who are working?
who are already working,
Yes.
and there must have been an assessment of what they are capable of doing within what time. that has enabled you to say, by a certain time, they will have reached they will have done the walls?
Because you can't have wall plates without foundations.
Of course, yeah. Yes,
And you must also be in the position to pinpoint it is in Belfontein, in wherever, all these other areas, to say these are the 3,500
yes. Now,
wall plates.
when you look at this document and you know what you know now about what the position was, namely what houses had been built, what houses had not been built, to what extent are you able to say that this document was really a misrepresentation? Because there's no way you could talk about walls when there are no foundations.
Yeah, it was, I'll call it, I don't know whether it is a wish list, I don't know, for lack of a better term, but it would have been highly unlikely that
Yes.
the National Treasurer, the parent department,
Yeah,
Human Settlement, will approve without knowing exactly, because you have to provide details about where those houses or where those foundations are, because we're talking about the wall plates. So you'll have to say they are in this particular area. And this is how, when you talk about the recovery plan, you have to demonstrate that. If that information is lacking, there's no way that it could be approved.
Yes,
And also on the face of it, it's improbable.
yes, but I'm asking a different question. You are the HOD. You were the HOD who prepared the affidavit that we are dealing with. Now, to the extent that this document was a representation to the national department, that the provincial department would achieve these targets by the end of the financial year, namely in March 2011. Are you able to say there was enough progress that had been made by October in terms of the building of the houses and the foundations and everything for them to have been able to achieve this? Are you able to say?
If you think about the 10%,
Yes.
that has been said, this is where you were
Yeah,
in terms of expenditure. Surely they were not enough,
yes,
whether foundation or wall plates,
yes,
or whatever the situation might be at the time,
yes.
to be able to achieve this.
But also, as at that time, based on what you know, what you got to know when you became HOD, are you not able to say there were not enough contractors, for example, who were qualified, who could have done such a job within such a short space of time? Is that something you are not able to say based on the reports you subsequently got when you became HOD?
Well, I'm not able to, I can only infer,
Yeah.
to say, in order to pull this,
Yeah,
you will need contractors also, because it's also about capacity to be able to pull. 3,500 also require a certain level of capacity and financial
yeah.
capital, financial capital.
But
So, and given the contractors that we know or we have in the sector, we are small contractors.
well, it would be good if this information is not already in the files here. It would be good if we can get information that tells me factually whether the progress that had been made in terms of the building of houses at the time this plan was made, October 2010, what progress had been made and whether by writing the targets that they were putting up here, it can't be said simply on that it was clear misrepresentation. So if that's not information that's available, I would appreciate it if you could work on getting that kind of information for us. But it ought to be possible because we're in 2020 now. We're talking about something that happened in 2010. At some stage in the years that followed, somebody ought to have said, let us see what was the position at that time. But on the information that must be available within the department, it may be able to reach some conclusion as to how much progress had been made. Based on that, was this not a clear misrepresentation? Yes, Mr. President.
Yes. But just to take a step back, I think you have fairly conceded that based on what you knew, it would not have been possible to achieve these projections.
Yes,
in the
unless
5
if you are able to say 3,500 wall plates, there they are, or foundation, there they are. You know. But where were they?
Well, your evidence is on record, but there's another way to approach it. Because at this very time, the department was devising a prepayment scheme which resulted in the expenditure of 600 million rand. Completely different parallel scheme. So at the time it's saying to National, we're going to spend this amount of money on this amount of foundations, this amount of wall plates, this amount of completions for each month from November 2010 to March 2011, and we're going to spend over R1 billion on this. At that very time, it is planning the expenditure of 600 million rand by way of prepayments to contractors and suppliers. Correct?
Yes.
The two can't sit together. We know that the prepayments of 600 million rand happened as a matter of fact. And if that was being implemented at this time, nobody could have believed in the truth of that diagram. Am I correct in that approach?
Yes. You don't seem very categorical on some of the matters, Mr. Mutsegi, where I would expect you to be quite categorical.
In what way?
You seem quite very guarded in terms of some of the answers. Whereas
No, where I agree. I said yes.
Yes. But it looks like there is a lot that maybe you might need to refresh your memory on, or what? For example,
No,
I
well,
would expect...
I think what should be appreciated as well, Chairperson, is remember it's and some of what is being said here is possibly hearsay because you know I was not there, but you know as accounting officer you also account for things that happened before you came. I think I acknowledge that, but also you know that the department lost money. It's a fact, and this which I drew up, or this affidavit, was amongst others mainly targeted at us trying to recover the money, firstly, and secondly, it's an affidavit that has been where I can't say I have a first-hand experience or first-hand information in terms of what happened. It's because of all the documents that one collected over time and tried to draw up this affidavit.
Well, going back to this, I mean, Mr. Pretorius is coming from another angle to look at this document to say nobody could have believed this information.
I agree.
Yes. Now, but surely you do have somewhere in the department information as to how many houses had been built by end of that financial year, namely end of March 2011. Even if you might not remember it now.
I might not remember it now,
But you have got it
but the source of that particular information, as I've indicated, will be the HSS.
Yes. Well, I would like that, because here is what was projected. What I would like is, if possible, by October, when this document was prepared, this was the state of affairs about this project. You
Yeah,
know?
I think we'll try and.
You'll try and do that, yeah.
And go back.
Yes.
Look also at, we'll also have to go and source documents like, because ordinarily there would be reports,
Yes.
the DORA reports on a monthly
Yeah.
basis that indicate where the targets are, you know,
Yeah.
where, how much and so on.
Yeah.
There will be those particular reports that we'll compare.
I
And
mean,
then we'll have to go back.
Even
to
if we are
2010,
not
11.
able to say even accurate number of units that had been built by October 2010, but a reasonable estimate might do. But from the mere fact that they'd spent 10%, about 100 million rand, that ought on its own to give us an idea that maybe on the base of 100 million rand or so, X number of units would have been completed. Can't be more, could not have been more. But out of whatever units they may have, they may have been working on, some of them might not have been complete. Maybe none of them would have been complete, but it could not have been more than X number, simply from the money, the amount of money that had been spent out of the 1 billion rand. And then you look at what was the state of affairs as at the end of the financial year. How many units had been completed, how many units were not completed. And in that way, one could come back to this and be able to say, whoever was drawing this document, if they knew exactly what we're talking about, they knew they were misrepresenting the position in a very serious way. Okay. Mr. Pretorius.
Thank you. Just to complete the point that I was raising with you, Mr. Moketsi, we know that during or about October 2010, the Free State Department of Human Settlements was still contemplating spending 600 million rand on materials, let alone completed work. Correct?
Yes.
So I think the conclusions you've reached were, at the very least, not unfair or unreasonable conclusions. Let's move to another topic. And that was, what were the communications from the National Department of Human Settlements to the Provincial Department of Human Settlements? On the 29th of October 2010, there was what is called a Technical Human Settlements MINMEC meeting. Now, there is MINMEC and there is Technical MINMEC. Could you explain to the Chair what they are, please?
Technical MINMEC is technocrats, officials, and is chaired by the DG. And all the relevant officials will be there, primarily all the HODs and the CFOs, and perhaps the certain support staff. That will be the technical MINMEC. The MINMEC is the minister and MECs. So the technical MINMEC then feeds into MINMEC for approval of whatever decision, whether it's policy issues and so on. So that's in short what it is.
Right. If you go to paragraph 44.5, what you say there is that at a technical min-mec of human settlements held on the 29th of October 2010,
Paragraph 44.
sorry,
You are
Paragraph
Paragraph
eight, because I'm still on the
44.5
ERP.
on page 110. I'm sorry. Let's
Paragraph
go back to page 110
110.
of your affidavit.
110.
Yes, Chair. Paragraph 44.5.
Yes. Paragraph 44.5, yes.
5, yes. There, reference is made to a technical min-mec, that's MIN capital MEC, meeting held on the 29th of October 2010. That would have been various officials from the National Department and various officials from the Provincial Department of Human Settlements, correct?
Yes, yes.
And you say at that meeting, Mr. Cheney, on behalf of the National Department, and Mr. Matlachwa, on behalf of the Provincial Department, were present, and that Mr. Cheney made it clear that payments were unlawful and impermissible. You see that?
Yes.
What payments were being referred to there?
I would, it could only have been the advance payments.
Advance payments. All right. Now, we,
Or for the purchase of material.
yes, you say in paragraph 44.6, you've relied for the account above on the evidence given by Cheney at the disciplinary hearing on 20 June 2013, and you give reference to the transcription of that evidence. We've looked at that evidence, and to be fair to you, Mr. Cheney is not entirely clear of when information reached the National Department in regard to the payments and the status of those payments. He talks about various meetings. There was an October meeting, there was a November meeting, there was a meeting at Velcom. Do you recall the Velcom meeting? But he's not entirely clear of precisely when National became aware of the irregularities. And it also was debated in the disciplinary hearing of what the National Department learned. On the one hand, it was put to Mr. Cheney that what the National Department learned from its chief financial officer, who had perused the housing subsidy scheme records, that payments were being made directly to suppliers, and that the complaint at that stage, at least, was that payments to suppliers is not a good idea. In fact, it's improper because there are no controls. You're simply paying to suppliers, and the suppliers can overcharge. They don't have, that system wouldn't have the control in the contract with a contractor who must receive, verify, put on site and the like. On the other hand, it may have been, and it's not clear from Cheney's evidence, that the nub of the complaint was the advance payments. But as far as you're concerned, the complaint was advance payments. Is that correct?
Yes, yes, advance payments. That's what we are dealing with.
All right. If necessary, we'll deal with that in submissions, Chair, or in, but I think it would not be fair to tax Mr. Mokesi on that issue. It lies within the mouths of others. So Mr. Cheney refers to various meetings. He was ill for a long time. He talks about an October meeting, a November meeting, and a meeting the following year. He talks about the risks involved in paying suppliers directly without going through the contractors, and he also talked, I think, about advance payments. But the sequence and the detail is elusive on his evidence, so let's leave that there. Okay? Your evidence, as I understand it, is that National complained that the plans of the province were unlawful and impermissible because they were advance payments. Correct?
Yes.
Yes. All right. Then Mr. Makachwa also gave evidence of events around this time. If I can give you the reference, Chair, it's bundle FS 17 at page 259. What he said is that he conveyed this warning that he'd received to the head of department, Mr. Mokoena. And Mr. Mokoena, and later the MEC said, you proceed nevertheless. Do you know anything about that?
No, I've seen it on the evidence of Mr. McCarthy. That's what I don't know anything about
You
that.
don't deal with it here.
Yeah.
We'll deal with that through other evidence, Chair. So the October meeting of MINMEC technical, you deal with at paragraph 44.5, but there are no minutes attached. Do you see that? You don't attach any minutes of that meeting when you deal with paragraph 44.5 and 44.6. You merely refer to Cheney's testimony. Correct?
For the technical and the main minutes.
Paragraph 44.5,
Yeah.
you refer to the technical human settlements MINMEC meeting of 29 October 2010. Correct?
Yes.
And over the page, you say what happened at that meeting. And in paragraph 44.6, you say, in saying that, what you say in paragraph 44.5, you rely on Mr. Cheney's testimony transcribed in the record of the disciplinary hearing.
Yes. Okay.
Correct.
Yeah.
There was another meeting, however, that took place on the 18th of November, another technical MINMEC meeting, and you deal with that at paragraph 54. Well, you deal with it at paragraph 50. You say in the second sentence, or you say in paragraph 50, I referred earlier to the Technical Human Settlements MINMEC meeting held on 29 October, at which Cheney advised Makachwa that the department's advance payments were unlawful.
Which paragraph, Mr. Petro?
50 on
50.
page 112.
Okay.
Then you say a follow-up Technical Human Settlements MINMEC meeting was held on 18 November 2010. You see that? And then you do attach a copy. And there you say, in paragraph 52, again, Makachwa attended on behalf of the department. He presented the department's expenditure recovery plan. So it seems that that plan was actually presented at an official meeting, according to this record.
Yes.
Correct?
Yes.
He also, that's in addition to presenting the plan, raised the proposed use of tripartite agreements in the housing project. Those are the agreements, remember, between the department, the supplier, and the contractors.
Yes.
Correct. That second level of agreement, not the session agreements, but the middle level of agreement. And you say in paragraph 53, the technical MINMEC meeting rejected the department's expenditure recovery plan. It warned the department not to implement it. Over the page, you say, paragraph 54, there were two major problems. First, the plan did not demonstrate the department's ability to spend its allocation in the few months remaining until the end of the financial year, 30 March 2011. Second, the proposed tripartite agreements were rejected since suppliers would have to supply materials in bulk without the necessary support to ensure quality and proper procurement proceedings. Also, there are a lot of risks with this arrangement. You see that. There were two issues discussed,
Yes.
as you say. But what is clear that at least at that stage, the department was not persuaded that the allocation could be spent. You referred to that earlier in your evidence. You recall that?
Yes.
Second, however, the proposed tripartite agreements were rejected. So it seems there were two issues on the table. The one is the expenditure recovery plan, which we've referred to, particularly that cash flow projection. And secondly, another way of spending money, which would be to pay suppliers direct. That was also rejected.
Yes.
Okay. Then it seems from paragraph 46 that another meeting was held on the 19th of November, that's the next day,
Paragraph 46
para 56
or 56.
on page 113, a human settlements MINMEC meeting held on 19 November 2010. Again, Mr. Makatwa attended on behalf of the department. You see that?
Yes.
Now that is with the national minister and the provincial MECs of human settlements, as I
Yeah,
understand
correct.
your evidence, correct? Is that correct?
Yes, that's correct.
Paragraph 58, the MINMEC meeting, that's the one on the 19th of November, confirmed the approach adopted at the technical MINMEC meeting, namely that funds would be shifted from non-performing provinces. That's the warning, correct?
Yes.
Paragraph 59, Mr. Makatwa returned to Bloemfontein and advised the then head of department, Paul Mokoena, that the department had been warned not to implement the expenditure recovery plan. However, Mokoena instructed Makatwa to proceed with the plan. I base this allegation on the findings of the disciplinary hearing, where this evidence is thoroughly dealt with and in detail. But your conclusion, I might say, accurately reflects the proceedings in the disciplinary hearing. Correct. That's where
Yes.
you got your information.
Yes, that's where.
Of course, having followed the instructions of Mr. Mokoena, Mr. Makatwa ultimately gets dismissed, but that's a story for later on in these proceedings. Paragraph 60, you say Mokwena's instruction was formalized by an internal memorandum. The memorandum was prepared by Musa Tsoametsi, who was then the Deputy Director General of the department. Mokoena signed the memorandum approving the recommendations it contained. There is some evidence to the effect that Mr. Mokoena requested Mr. Tsoametsi to prepare a legal opinion on the legality of the issue, but that document prepared by Mr. Tsoametsi is not an opinion at all. Do you know anything about that?
No.
Of course, the memorandum itself, as you point out in paragraph 62 and following, which served to implement the advanced payment plan, was itself not followed, let alone it not being proper in the first place to even contemplate such a plan. The plan that was contemplated was also not followed at all. And you detail that in paragraph 62 to 64. Basically, the memorandum prepared by Mr. Tsoametsi said that the department would only pay material supplies for material actually supplied to a contractor and invoiced, with the invoices to be backed up by a certificate issued by the contractor confirming receipt of the material. That's contained in the memorandum. But that's not what happened, am I correct?
Yes, that's not what.
What happened in fact?
Well, materials were either not delivered or instances, and this is what we also picked up, they were either not delivered or instances where they were delivered, they were not delivered in the quantities that are required, or they simply, some of the contractors denied that the materials were ever delivered to them. And then this is what we were faced with. To say in certain instances, we had suppliers just dropping materials on site without any supervision and so on. So that's basically what happened. But in terms of the certification of the material, as contemplated in the memorandum, it didn't happen. It happened only to a very lesser extent where it happened. It did happen in certain instances, but not in all instances.
You summarize that in paragraph 65 and 66 on page 115. If I may just read that and you can confirm whether it's correct or not. Paragraph 65 on page 115 reads, "The department's decisions were in clear breach of the advice given to it by the National Department via Cheney and the technical MINMEC meetings. The department had been told that its expenditure recovery plan was not acceptable and that it should not implement it. It had also been told that paying suppliers without the suppliers having supplied materials was unlawful." Is that your analysis of the documentation that you looked at?
Yes.
All right. We don't have a minute, I must say, of the expenditure recovery plan being rejected, but we do have a minute of suppliers' payments being warned against. But that's part of the record that we can deal with the chair in submissions. Paragraph 66 goes, "As I set out in more detail below, the department proceeded to make payments to suppliers without the suppliers having supplied material, i.e. it made payments in advance. No written agreements were concluded governing these payments. The department did not follow any proper procurement process to identify the suppliers to which it paid payments. The total value of the payments made is nearly 1 billion. Now that's in relation to the prepayment scheme. Does that reflect your researches into the materials that you referred to in paragraph 4 of your affidavit?
Yes.
Right. Before I get to the next topic, I'd like to just make one point or put one issue before you. There doesn't appear to be a minute of the national department at a technical MINMEC or even a MINMEC or any other meeting saying to the provincial department, your expenditure recovery plan cannot be implemented, it is unrealistic. We don't have a minute of that. And if, in fact, the national department was saying, look, you can't pay suppliers directly because it's too risky, then, of course, it wouldn't be commenting on the expenditure recovery plan, it would be commenting on the other process, correct?
Can you repeat that?
Sorry, it's a long question, and it's been a long day. We don't have a minute of any meeting where national says to provincial, don't implement the expenditure recovery plan. We don't have a minute of a rejection of the expenditure recovery plan. One can, of course, argue that had they looked at it, they would have obviously come to the same conclusion, or that they actually did reject it, as you say.
Yeah, one can only infer because yes, that ERP was prepared. It must have been prepared, and the way we know the process is that the recovery plan you present it to the technical meeting. Either it will have been presented to these performance reviews, which are not necessarily technical MINMEC per se, or they will also be presented in the technical meeting where it will be approved or rejected. There should have been a process that decides that we are taking money from you to that province or provinces.
That's what
It must
happened,
have
in
been.
fact.
I mean, and it happened.
Yes.
So, there must have been some sort of an engagement,
Yes,
and
sure.
some sort of a correspondence.
One can infer too that if they'd asked for it, if the minister had said, give me an expenditure recovery plan, they would have looked at it, and I would imagine, and I think it's reasonable to put to you, would not have been convinced by it. As you say,
Yes, there would have been.
they would not have been convinced by it.
Yes.
Yes. Because clearly on the face of it, it was not an achievable project. But you've given that evidence, I don't want to repeat it. We might get into another round of exchanges. But the second point I wanted to make arising out of that is that a rejection of the idea that suppliers should be paid directly and not via contractors is another matter. It's a separate matter. Correct.
Okay, yes.
Yes. Right. Well, we needn't take that much further than that. If I could take you to paragraph 72, that refers to certain press statements. And if you go back to paragraph 69, you record there that on the 18th of January 2011, the National Department issued a media statement
Yes.
saying that it was shifting funding from underperforming provinces, the Free State and KwaZulu-Natal, to other provinces. Correct.
Correct.
And the response of the department to that was to say, no, we're going to spend everything by the end of the financial year. By the end of January, in its response press statement, the Free State says, according to paragraph 70, by the end of January 2011, expenditure should be around 85%. Now, if one includes the 600 million plus spent on advance payments, that might or might not be correct. We don't know that.
We don't know that.
But you do say in paragraph 72, by the time these statements, these press statements were issued, the department had already transferred several hundred million rand from its conditional allocation to suppliers, and I stress suppliers, and that would have been for material.
Materials, yes.
It continued to make unlawful transfers in January, February, and March 2011. The transfers were made without the suppliers having supplied material, without written agreements in respect of or regulating the transfers, and without any procurement process having been followed. Correct?
Yes.
You agree with that
Yes.
statement?
Yes.
And then paragraph 73, the department made the transfers for the purpose of avoiding having its conditional allocation stopped and transferred to better performing provinces. That was the object.
Yes.
It made the transfers so that it looked as if the conditional allocation had been spent. I submit that this was a fraud on the National Treasury and on the national government more broadly, as well as on the taxpayers and the public generally. That's a repeat of your earlier statements
Yes.
regarding the fraud. Correct.
Correct.
I repeat that the unlawful transfers, you say in paragraph 74, amounted to plus minus 631 million rand in total. That deals with that section. You deal with the material supply agreements in paragraphs 87 and 88 of your statement. That's on page 124. You see that?
Yes.
That's between October 2010 and August 2011, the department concluded approximately 112 agreements termed material supply agreements. These were the tripartite agreements of which we've spoken earlier.
Yes.
They're well summarized in the judgment of Paul A.J., which we may refer to because they're a convenient summary, but we could do that at a later stage, perhaps by way of revision tomorrow morning. But what is instructive about that statement is that at the very time the expenditure recovery plan was being devised and presented to National, that's October 2010, this parallel scheme of material supply agreements to spend 600 million rand was being devised. Correct.
Yes.
You then deal with, in the following paragraphs, the material supply agreements. And you highlight certain provisions of the tripartite agreement. Firstly, there's the conflict between the contractor's obligation to source materials and pay for materials and the department doing so directly with the supplier. You recall that conflict?
Yeah, the material supply and the contract.
Yes.
Yes.
The contractors with a contract.
Yeah, because the material supply was put the responsibility of acquiring material was now put on the
Now it was clear.
department.
Right. The agreement, you say in 90.2, obliges the contractor to order its building material from the material supplier. But now in the tripartite agreement, there's a possibility of a direct link between the department and the supplier.
Suppliers.
Correct.
Yes.
But what is interesting about this tripartite agreement in paragraph 90.3, which you point out, there are no fixed prices. So in other words, the supply agreement is entered into with the hope, as you put it, that the material would be supplied at the best price. So one enters into a contract with no price being fixed, and the material supplier is told, just give us your best price. You make the remark later about whether this is a commercially viable way of going about business. What is your remark about that?
Well, there's an element of risk, particularly for the contractor, because all the milestones prices, you know, foundation, wall plates, those prices are fixed. Now, if you don't manage, because the biggest input in building of houses is material. It constitutes perhaps 80 or 90% of the input costs. Now, if you don't manage that particular issue and will simply leave it to the material supplier, you run the risk of material suppliers either overcharging, and unfortunately, because the price is fixed, the contractor possibly, because we pay a fixed price, you know, 100. If we say foundation is 10,000, that's what it is. That's what we are going to pay. So you can end up actually, if you do not manage that material part of it, the contractor can end up actually spending 12,000 for argument's sake, and we are certainly are not going to pay 12,000. We are going to pay 10,000, and that it will obviously, what's going to happen is the contractor will abandon site because he is obviously losing money. So that's the risk, basically.
In summary, Ms. Moketsi, at page 125 and page 126, you deal with the terms of the tripartite agreement for the supply of materials, the agreement which provided for direct payment at no fixed price, as you point out, by the department to the supplier as opposed to the contractor. And you point out on page 127 how these tripartite agreements varied the contracts with the contractor. To give the simplest example, the contractor was originally obliged to source materials and pay for them, and would only be paid by the department once they were the building milestone had been completed. This provided for an upfront payment directly to the supplier without the controls that you've referred to and creating the risks that you referred to. All that is detailed here. I don't think it's necessary to go to it in any detail. It's clear what you say here, and that's backed up by an examination of the contracts and by the findings of Advocate van Graan in the disciplinary inquiry. You make the point in paragraph 95, in addition, on page 128, that this material supply agreement is most unusual in the construction industry, and it is at odds with the requirements of the housing subsidy scheme. Correct?
Yes.
You see that in paragraph 95. Again, we don't need to go into detail, except perhaps to say in paragraph 95.2, what you say is that there's a departure from the requirement that materials actually be incorporated into the houses being built into the satisfaction of the employer before the employer is required to pay for the materials. That's the department. The department would ordinarily, in proper expenditure process and in accordance with all the regulations and the regulatory framework, have to be satisfied that the materials are actually there in the completed house before it pays for them. Correct?
Yes.
And you also make the remark at the bottom of paragraph 96 on page 129. The department paid substantial amounts of money, often with no invoice at all.
Page?
Page 129, the last three lines of the first paragraph on the page, paragraph 96. The department paid substantial amounts of money, often with no invoice at all. Where there was a document purporting to be an invoice, it was not certified and was often patently false. You've given that evidence.
Yes.
And those examples would appear in the reports. Then, at the bottom of page 129, you deal with the session agreements, and if we're going to complete the summary, we should deal with those. But before that, Chair, I would want to deal, and I see we're beyond the time now. I'd like to deal with another topic, which I'd like to deal with tomorrow also. Would this be a convenient time?
Yeah, I wanted to find out whether, in terms of how much time we will need during the week, whether we need to go beyond 4 o'clock or whether we should stop at 4 o'clock because we'll be able to manage.
Well, I was hoping to finish the evidence well in time.
Well in time?
Yes.
Okay. Then in that event, let's adjourn then, and then we'll continue tomorrow. Okay. We'll adjourn, and then tomorrow we'll start at 10 o'clock. We adjourn.
He doesn't know if they continue. The whole Crown says that he did it. Our only concern. You've never seen me so quiet, Paul. You've never seen me so quiet.